ಅಯ್ಯೇ ಆರ್ಡರ್ಸ್ ಅಂತಾರೆ ಅದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಐತ ಅದ್ರಲ್ಲಿ ಒಂದು ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಒಂದು ಹಿಸ್ಟ್ರಿ ನನಗೊಂದು ಇದು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ಯಾವ ತರ ಒಂದು ಪೇಜ್ ಮಿಸ್ ಮಾಡ್ಬೋದು ಅದರಲ್ಲಿ
ಅಮೌಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಯಾಕೆ
ನನ್ನ ಮಟ್ಟಿಗೆ ಇದ್ರು ಅವರು ಏನು ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ ನಾವು ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಅವನೊಂದು ನೋಡಿ ನನಗೊಂದು ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಂಬರ್ ಕಳಿಸಿ
Ma'am, list 2 ತಗೊಂತೀರಾ, list 1 ತಗೊಂತೀರಾ? List 2 or list 1? ಅದಾದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತಾ? ಓಕೆ. ಓಕೆ.
ನಾಳೆಗೆ ಕಂಪ್ಲೈ ಮಾಡಿಸ್ತೀನಿ.
ಆಯ್ತು ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್
IML.
ಓಕೆ, ನೀವು ಅಲ್ಲೇ ಇರಿ. ಅಕಸ್ಮಾತ್ ಕೇಸ್ ಕರೆದ್ರೆ ಜಸ್ಟ್ ಪಾಸ್ವರ್ಡ್ ಆಗುತ್ತೆ. ಡೇಟ್ ಕೊಟ್ಟರೆ ಕೊಳ್ಳಿ, ಅಷ್ಟೊತ್ತಲ್ಲಿ ನಾನು ರೀಚ್ ಆಗ್ತೀನಿ. ಇಲ್ಲ, ಹೋಗ್ಬೇಕು. ಕರೆದ್ರೆ 4 ಜನನೂ ಒಳಗಡೆ ಹೋಗಿ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಆಗಲಿ, ನಾನು ಬರ್ತೀನಿ ಅಷ್ಟೊತ್ತಲ್ಲಿ. ಓಕೆ. ಹಲೋ, ಟೋಟಲ್ 20. ಸರ್ ನೋಡಿ ಸರ್. Your Ladyship, this moving a memo, my lord. There is extreme urgency. The recovery proceedings have been initiated against me in the Surface Act proceedings. My lord, the respondent is about to take possession today itself, my lord. Maybe.
When did you come to know?
My lord,
When did you come to know?
the bank authorities have informed me 2 days back, my lord.
You have no notice.
Notice was issued to us after the tenants of the property were communicated that a notice of this nature has
All
come to
that
us, my lord.
kind of lunch motions and all, I'll not permit. All these proceedings will not happen in overnight. You know, let it come. I will see, give the memo.
Your
I will
Ladyship,
see the
it may be listed, Your Ladyship.
Huh?
The matter may be listed because they are about to take physical possession of
Let them
the
take.
property and the
And first
tenant.
of all, why should how a writ petition is maintained? On what ground you are coming to this court? These kind of matters will not be entertained. That is how all these surface matters are filed. Let me look at it. If I feel there is urgency, it will come tomorrow. If not, it will come some other day. Whoever is giving the memo, please write the urgency on that. I will understand the urgency from what is written on that. Yes, give all the memos. Call the list.
Submission.
Page, please.
Submission, my lord. By vehicles has been seized, which was hypothecated. Yesterday evening, they have, by way of register post, they have sent me the letter saying that I am auctioning the entire vehicle today, tomorrow at 11 PM, my lord. I have paid my EMIs, except on you.
Let it come, we'll give it, we'll list it tomorrow.
Amar Ahmad submission.
My lord.
FR 319425. The vendor, the purchaser is not owed any loan from the respondent number 1 and 2 bank loan. Earlier vendor is already mortgaged the property and he has availed the loan.
What to
Today
do
auction
then?
has been conducted, Your Honor.
What to do? It's already conducted. What is that we can do now?
Kindly matter is urgency
What
for,
can be done today, it can be done tomorrow also.
matter is urgency today for public auction, Your
All,
Honor.
no urgency at
The
all.
petition is not availed any loan, Your Honor.
Then we will see tomorrow.
Earlier vendor is already,
We will stall it tomorrow. Today, if they conduct auction, nothing that they will do something.
yesterday
today.
already moved the application, memo for
If
urgency.
you moved the memo, I must have given a date.
No, yesterday, tomorrow is given date, Your
Yes,
Honor.
tomorrow it will come. Yes.
My humble submission.
No, I'll not take up. Let's give all the memos to the court officer.
Then the matter-
No lunch motions will be granted. Give it to the court officer. I will look at the urgency. If there is urgency, I will grant tomorrow or some other day.
Lord's kind indulgence,
My
lords.
apology, my lords, when the matter is pending, I have the benefit of stay, my lords. In the meanwhile, the respondent rushed to the court and filed execution, my lord. I filed a IA for stay that.
Let it come tomorrow, not today.
Yes,
Yes.
my lord.
Lords, one matter.
Give it, yeah, please write the urgency
Please.
on that. When is the matter going to come up and all?
Please.
Basing on that, I'll grant.
My lord,
If-
the
if-
matter is
If
pending,
any
my
of the
lord.
memos do not disclose urgency, I will not grant any date.
Please, my lords.
Yes.
I have the benefit of stay, my
We will
lords.
see, we will see all that arguments you please reserve when the matter comes. in.
Lords, with kind permission, lords. Lords, I am a tenant, my lords, mortgagee, registered mortgagee. Lords, loan was obtained after the mortgage, my lords. Lords, without seeing, lords, lords, the landlord, lords, without disclosing the mortgage, lords, has obtained the loan. Lords, how the bank, lords, has given the loan, lords.
All that we will see.
Lords, urgency is this, my lords. 13-4 notice is issued.
Let it be.
Lords,
We will see it, we'll see it.
Lords, lords, it may be taken up tomorrow, my lords.
You give it, give the memo. Did I say that I'll not take it up tomorrow?
It's tomorrow, my lords.
Give the memo, write the urgency. If I feel that there is urgency, then I'll grant.
Page-wise adjournment. List 1, page 1, serial number 2 to 6. Page 2, serial number 7 to 11. List number 2, page number 3, serial number. Number 9. Page number 10, serial number 32 to 35. Page number 11, serial number 36 to 45. Page number 12, serial number 46 to 50. Page number 13, 57, 51 to 59. Page number 14, 60 to 65. Page number 15, serial number 66 to 69. List 1 for being spoken to, serial number 1, Pratima SK.
My lords, kindly, my lord, say list 4, my lord, serial number 50. List 4, my lord, serial number 50, my lord.
Yes.
My lords, this is only with respect to the date payable, my lords. Page 9 of the impugned, the order that was modified by this honorable court, my lords. Point number 1. Your lordship has directed maintenance as well as educational expenses. At point number 1, the educational expenses has been clearly mentioned that shall continue to pay during the pendency from the date of application, my lords. However, at point number 4, my lords, the father shall pay the maintenance of an amount of rupees 10,000 per month to the child. That has been left out. Now it is understood when your lordship has directed educational expenses from the date of application, even maintenance has to be from the date of application. However, they're refusing to pay from the date of application and they want to pay from this order dated. That is the only
My lord, we
clarification.
have filed review petition number 439/25 for modification of the order for several reasons. Let this memo and review petition be posted tomorrow or Monday.
The review will be filed seeking modification of the order.
Yes, my lord,
It will be reviewed on that.
I have reviewed. I have sought review for 3 reasons.
So how many times the court will hear a
No, my lord,
matter and
what-
after that a review?
Review.
That's passed before you.
No,
that
my
order
lord,
was passed.
I'll make my submission, my lord. There are 3 things here. One is that to pay the maintenance to the child. Your lordship has clearly said at the time of passing of the order, that is from the date of this order, pay 10,000 rupees.
Not at all.
Educational
If I say so.
Not at
No,
all.
my lord, no,
sorry, I'm sorry.
May
I'm sorry.
make my submission, my lord.
No, what I'm saying.
No.
You listen to me first. I'm saying if the court says all the videos are available.
No, my lord,
you can look at from the video.
I heard so. Educational expenses from the date of application, your lordship said, that is what is mentioned in the order here. Now, what I am submitting here is, now already it is 1.5 months or 2 months that the order has been passed. Determination of the school fees has not been decided by the court, though 8 weeks time has been granted. So my submission and my proposal to the other side is, we will deposit 10 lakhs rupees in the name of the child, which the child can release it after he attains majority. Let the case be proceeded with the further, because
Who will take care of the expenses of the child?
Please, my lord.
Who will take care if he realizes it after he may become?
No, from this year, academic year, I am taking the responsibility. I will pay the fees.
Yes, take that number, list along with that on 12th of November.
RP number 439/25.
Write on a paper and please give.
Please, please.
Grateful.
RP.
Hearing serial number 2.
In this case,
HR Sanjeev Gowda.
I am for the petitioner hearing, my lord.
RP number.
Lord, the petitioner hearing has filed.
Please use the mic.
Sir, mic use
RP
ready.
number 439.
My lord, the petitioner hearing has filed the petition
25.
before the.
Where is the impugned order, page number?
Each in the.
My lord, I am seeking direction to dispose of the matter within.
Which year is the MC?
MC is the 2023, my lord.
Why should it be disposed of now?
This is the second round litigation. In the year 2021, the petitioner hearing has filed a petition under section 9 of the Hindu Marriage
Even
Act
if
for-
it is 21 also,
Then
we
that has
cannot
been-
pass any order.
that has been
Because only
withdrawn.
they will dispose of the matters in
Milord,
2019.
My lord, since from 1 year it is for cross-examination of PW1.
Not only your case, it is a case of thousands and thousands of cases that are pending before the family courts. So no exception to one party. Please come. The present writ petition is filed, seeking the following prayer. Extract the prayer. When counsel for the petitioner submits that this is the second round of litigation. Earlier in the year 2021, restitution petition is filed. Now this petition is of the year 2023, which is filed for divorce. It is submitted that the matter is pending for cross-examination from the last 1 year. Hence, there shall be a direction to the family court to dispose of the matter as expeditiously as possible. Next paragraph. This court is not inclined to pass any orders directing the family court. Which family court it is pending?
Sixth additional.
Sixth additional family court to dispose of this matter as this MC was of the year 23, and even the other MC which the petition is referring is of the year 21. This court has already passed direction to the family courts to dispose of the oldest matters, and they will be taking up the matters till 2019. So no priority can be given to an MC which is of the year 2023. Accordingly, this court do not find any reasons dismissed.
Serial number 3, Leela P. Devadiga for petitioner.
My lords, in this matter, my lords, the petitioner, who is the wife of the respondent, my lords, had filed a petition for restitution of conjugal rights, and thereafter, my lords, she had sought for
You're
interim
seeking
maintenance.
enhancement of the maintenance.
My lords, as of now, I'm seeking stay order on the pending proceedings, my lords.
Why?
My lords, the husband, my lords, he is residing in.
No, what is the impugned order first?
My lords, the impugned order, my lords, it's a common order, my lords, on IA number 7 and IA number 8.
Where is that?
My lords, at annexure A, page number 16, my lords.
15.
16, my lords. My
Yes.
lords, the petitioner had filed 2 IAs, my lords, IA number 7 and IA number 8. IA number 7 is for is sought to issue direction to the respondent to produce 18 documents, my lords. And
You're for
IA
the
number
wife.
8,
You're for the wife.
please, my lords. IA number 8 is sought to summon the bank account extraction of the respondent and his mother, my lords, from the SBI bank, which is in Mangaluru, my lords.
Let's see the reasoning given by the court.
Please, my lords.
Read from the reasoning part.
My lords, I would like to make a mention, my lords. My lords, before these applications, the respondent had
No,
filed.
what we do is, let's read this, whatever submissions you want to make, you can make later. Read from paragraph 8.
MC number 189 of 2023 is filed by the wife for restitution of conjugal rights, and MC number 77 2024 is filed by the husband for dissolution of marriage. It is an admitted fact that the husband is working in Sharjah. The petitioner has sought to issue direction to her husband to produce copy of PAN card, IT returns, FT receipt, copy of LIC policy, profit and loss account of PKM Studio, bank account passbook, passport, khata documents, present salary certificate, house rent agreement, mobile number, and copy of the RC of Maruti Suzuki Swift Desire car. It is relevant to note that it is mandatory on the part of the parties to produce all documents in support of their respective affidavit and assets of liabilities. If all and any party has failed to produce the same, the court has the power to take adverse interference against the said party. Moreover, the respondent has already produced his ICICI bank statement,
Yes, I've
salary
seen.
slip. Please, my lords.
I've seen the order.
My lords, the petitioner, my lords, is he is diverting his income to his mother's account, my lords. That is in SBI bank, which is in Mangaluru. That has not been disclosed, my lords. She has sought for producing certain documents by the respondent, my lords. My lords, the thing I wanted to mention is, prior to these applications, the respondent husband has filed IA number 5, my lords. The order on IA number 5, my lords, is found at page number 22, annexure A1, my lords.
Yes.
My lords, the husband has given a SPA to his brother, my lords, to contest in the matter, my lords. The operational portion is at IA number,
I've seen
page
that.
number 25, my lords.
I've seen that.
My lords, he is allowed to, the SPA holder is permitted to appear before the court on behalf of the respondent to conduct the case. My lords, the SPA holder has filed the affidavit of assets and liabilities. He has not disclosed all the income and assets of the respondent.
So, as per the judgment of the apex court, if he has not disclosed something, then the court will take an adverse inference against him. That's what the court has rightly observed.
My lords, it will still affect her rights, my lords.
No, if adverse inference is drawn, whatever you have asked for, the court will grant.
My lords, if the application would have been allowed, no hardship would have been caused to the respondent husband, my lords.
Please come. Agreed with the orders passed in I number.
My lords, in the IA, my lords, she has specifically mentioned that the respondent husband has also filed for a divorce petition. He's also not paying any interim maintenance to the wife and the child, which is with the petitioner.
Your interim application will be decided provided you will not come up with these kind of applications. If you keep on filing the applications, when will the court grant interim maintenance to you? You are only contributing to it.
My lords, at least something he has deserted her from the
provided
last.
an order is passed, but you are not letting the court to pass. You are coming up with what is this number without granting interim or maintenance. Now IA number 7 and 8 are going on now.
Please, my lord, she wants a full disclosure of the assets and liabilities that he has.
The court, the finding of the court is as per the judgment of the apex court. Please come. Agree
My
with
lords,
the order.
my lords, the family court has not considered the settled principle of lifting.
What
the
is
bail-
that?
Of lifting the
Settlement
bail
principle
in
is
financial.
Rashish versus Neha, as far as these matters are concerned.
No, my lord, lifting of the bail in financial matters involving financial numbers, my lords.
For your sake, notice. Notice.
My lords, the diversion of funds is involved, my lords. Only.
I want to dismiss it, but anyhow, you're insisting, notice. Notice to respondent. Petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect. Once the memo is filed, this is the matter. Next.
Till number 4, Naveen Kumar M for petitioner.
Appearing for the petitioner, my lord. This is the case. Trial court order for the maintenance to the respondents, my lord. Where this marriage is the respondent earlier married to Mr. Rajachari, I have produced Annexure F, page 51, my lord. This is earlier marriage. Subsisting, when the marriage is subsistence, second marriage is the void. The marriage, second marriage is void. Then the trial court ordered for the,
You can get married to her. When the
No, no.
maintenance aspect comes, it becomes a void marriage.
so she's paternal aunt's daughter. She's my relations, then she misused my relations, then he approached the court, my lord.
No, you married her. You would not dispute that. Now, when the court grants maintenance of 5,000, now we'll come to the court and say, already the earlier marriage is subsisting, so this is a void marriage. She's not entitled for maintenance.
Yes, ma'am. So another one thing, ma'am. She's living with another person that I have produced.
Adultery and all other issues cannot be decided by the court in an IA.
Then that I have not produced the marriage certificate, marriage card before the trial court. Hence, the trial court ordered to pay the maintenance, my lord. The reasoning part given by the family court, I will read the.
You accept that who filed the MC?
My lord?
Who filed the MC?
Respondent filed them.
What is that she's seeking? Restitution.
No, dissolution of marriage. She is seeking for dissolution.
On the ground of?
On the ground of cruelty, my lord.
Oh. You have filed your objections to that?
Yes.
Where is that objection?
No. Objection is page 42, my lord. Page 42, Annexure D, my lord.
Let's see.
That I will read the second paragraph. It is submitted that the averments made in second para of the petition are the false story fabricated.
Learned by the respondent that the petitioner got married to one Puttaraju
Yes,
in the year 2010.
10.
How did you learn? What is the material?
The Annexure F, my lord. Now I produced the
Annexure?
Annexure G, my lord.
What is that?
Annexure F, page 51, my lord. That's name Puttaraju, name Pallavi. On the marriage solemnized on 1/7/2010, the place of.
Subject to proof.
My lord?
It's all subject to proof.
Yes, my lord. So I couldn't produce the before the trial court.
Even before this court also, this court can't consider this. Just like that, you can take this, you can take a printout in this manner. And what do you say about your marriage? Do you deny the fact that you got married to her?
No, I am didn't married because of it.
What I'm asking from this, where did you say that? From your objections, let us read that.
I read.
Where is it?
So one opportunity for the produce the records, my lord. Marriage invitation, other.
Let's read from your objections. What did you say?
The petitioner in the third para, my lord, page number 43, it is submitted the government's third para of the.
That she produced to show that your wife and husband.
She has produced that is same marriage card, marriage card, only marriage card and photos. When she has taken the photos, she has produced the same. Other no.
So she has prima facie placed before the court the material to show that there is a marriage.
Yes.
And you are living together.
So it's a void marriage.
Void that the court will decide later. Please come. The present petition is filed. Agreed with the orders passed in. How come a writ petition is filed? Which is IA?
Annexure.
IA number.
IA 1 of 25.
Court doesn't even mention that. had filed a simultaneous 1000 of 2024 seeking maintenance. In that, she has filed an IA seeking interim maintenance. By order in fuel, the court had granted an amount of rupees 5,000 per month. It's a case of the wife that the petitioner and the respondent were married on 5/3/2013 at Hospet Taluk, Bellary district. After that, they lived in Hospet Taluk by securing a rented house and stayed there for about 8 years. During her second month's pregnancy, she suffered health issues, went to her parents' house, and after 5 months, she returned to her matrimonial home. After returning to the house, she noticed that he developed illegal relationship with another woman, and the respondent quarreled with him. Later, with the intervention, the said dispute is settled. On 4/5/2015, she gave birth to the second respondent herein, and the petitioner had looked after them for about 1.5 years. In view of the disputes between the parties, she started living separately, and she has filed a present petition seeking maintenance. The respondent has filed his objections. According to him, there was no marriage between the petitioner and the respondent. She's the maternal aunt's or uncle's,
Paternal aunt's,
paternal aunt's son, taking advantage of
paternal aunt's daughter, she is.
paternal aunt's daughter, taking advantage of the said relation. She has concocted this story. According to the petitioner, she is married in the year
10.
2010, and during the subsistence of the said marriage, the second marriage is void, and the petitioner is not liable to pay any maintenance to the wife. The court, by order impugned, while granting a maintenance of 5,000, the court has observed that
12th para.
the wife has prima facie has shown that the children are born on 4/4/2016 and 2023. Which shows that since 2006 till this day, what has prevented the husband from taking any action against the wife if really she had concocted the documents showing that he is the father? The husband has not produced any document to prima facie show that that she is legally wedded wife of some other person. And para number 2 of the statement, he has contended that she is a wife of one Puttaraju alias Raju.
Yes.
Got him married in the year 2010. Whereas in his subsequent pleadings, in para number 14, he has referred to the name of one Rajachari as her husband. The court observed that his own pleadings were apparently shown to be inconsistent. Moreover, not a single document is placed before the court to show that she had married the said person prior to marrying him. And accordingly, the court had granted the maintenance. Land counsel appearing for the petitioner has reiterated the grounds that are raised before the court and submits that that the only ground on which the petitioners, the court has granted maintenance and rejected the case of the petitioner is that he has not produced any document. He files a document before this court. That is the marriage card to show that she married another person, and during the subsistence of that marriage, she cannot say she got married to the petitioner and as it's a void marriage. It is submitted that when there is no when the marriage itself is void, the husband is not liable to pay the maintenance. Next paragraph. Having heard the counsel for the petitioner, produce the material on record. When a petition is filed seeking maintenance, when an IA is filed seeking interim maintenance, first the prima facie, the wife has proved that there is a marriage, and out of the and in the wedlock they are blessed with 2 children who are 9 years and 2 years old. Before the trial court, the husband has not placed any document. However, before this court, he places a marriage invitation card. In the considered opinion of the court, basing on the said document, this court cannot come to any other conclusion at this stage and cannot consider the said document at this stage, which is always subject to proof and relevancy. While considering the IA for interim maintenance, court has elaborately discussed and considered, and all these contentions are always open to the petitioner at the time of hearing the main petition. And at this stage, no order, at this stage, there cannot be any finding that it is a void marriage. In these circumstances, this court do not find any reasons to interfere. Dismissed.
Cell number 5, Kiran sir.
I'm for the, my lordship, I'm for the petitioner wife. It's for enhancement of maintenance, my lord.
Notice petition is
I may be
permitted
permitted by,
to hand
take it
summons
by hand.
and shall file a memo to that effect. So once it is filed, it's the matter.
I may be permitted to serve it on the council appearing before the trial court. my lord.
Appear for the petitioner wife, mother, your lordship. The petitioner has challenged the order of the family court wherein custody rights have been given to the husband from 10 a.m. in the morning to 7 p.m. on Saturday. Your lordship,
permitted to take court hand summons.
your lordship, one other aspect is, your lordship, he is mentally unwell, your lordship, he is an alcoholic. He also solicits.
You please take out hand summons, file the memo. Immediately it will be listed. I will not interfere in any of the custody matters without notice to the respondent.
Please.
Cell number 7, Siji Malai.
Please come. The present writ petition is filed, seeking a direction to the family court to dispose of I number
2, my lord.
I number 2, which is filed seeking visitation. When counsel for the petitioner submits that this IA is filed in the year 2024. That's on 21/9/2024. Even after a year, the said IA is not disposed of. Then this court has called for a report from the 6th Additional Principal Judge Family Court at Bangalore. Why an application seeking visitation was kept pending from the last 1 year. On that, a report is placed before the court by the learned judge stating that when after the husband has filed I number 2,
3, my lord, sorry, my lord. Stand
I number 3.
3.
I number 3. Husband's IA is 3. After the husband has filed I number 3, the wife had filed IA number 6, seeking a direction, restraining the husband from visiting or approaching her residence or school of their minor child. Due to the said IA, the earlier IA that's filed for registration could not be disposed of. It is stated that there is a huge pendency on the file of this court. As on 1/10/2025, there is total pendency of 2751. In view of in view of these facts, he could not dispose of the IA. Now the case is posted to 3/11/2025, and on that day, the said IA will be disposed of. Next part. Whenever a report is sought for from the family courts, it has become a routine practice to state how much burdened they are. The High Court is conscious of the fact that what all the matters that are pending before the court. In each and every report that is placed before the court, it is not necessary for the learned judge to mention this. Whatever is the pendency, when an IA is filed seeking visitation or interim maintenance, it's a duty of the court to give priority to those IAs which requires immediate attention of the court and which is in the interest of the parties. If the wife files an IA restraining the husband from visiting or approaching the respondents, approaching the wife's residence or school of the minor child, that cannot be a ground for the court to keep the IA number 3 pending. IA number 3 and IA number 6 at a time could be disposed of by the court. Within 1 month from today, the case shall be disposed of. The IA that's filed, both IA number 3 and IA number 6 shall be disposed of by the court. And hereafter, these kind of reports shall not be, these kind of reference shall not be made in the reports whenever sought, as if trying to tell the court that they're overburdened and the High Court is asking them to dispose of the matters. Earlier also, this court made it clear that this is not the manner in which a report will be placed before the court. The Registrar Judicial is directed to communicate this order to all the judges so that in future, these kind of reports by stating these kind of amendments will not be placed before the court. Yes.
Cell number 8.
No.
Yes, Lakshmi Narayana for petitioner.
Petitioner is case. Annexure A is the impugned. Petitioner is the husband. Operating portion is at page number 23. The petitioner husband is a handicapped and is a flower vendor on the footpath.
How much is granted?
Total wife 5,000 and one son 4,000. My lord. His income is average 5 to 10,000 per month. He is a flower vendor in the footpath side.
What about his physical?
Another son is.
No, where is it discussed by the court? Please come to
Not
that.
at para number 14, my lord, page number 21,
Please
inner page
read.
11, 5th line, my lord. It has recorded, my lord. The petitioners got produced one photograph by stating that respondent is selling flower in footpath and except the income earning from the said
But
business,
you
he
were
has no
saying-
any source of income.
You are saying about that he is physically handicapped.
Please, my lord.
Where is it?
My lord, he has not mentioned it, my lord. He has to file his documents, my lord, before the court. Trial is
It's not even your amendment.
They have taken the contention in
Where
the,
is that?
please, my lord, at the objection, statement of objections is filed at page number 35.
30?
5, annexure C, 1.
Where did you say?
Yes, my lord. Para number 8, my lord, last para, my lord, page number 37. Further stated that first is not in good health condition and he is unemployed and has no source of income. It is further first state. So the mother of the petition is not in position to look after the
From this, we
petitioner.
have to infer that He's a
Yes, my lord.
handicapped person.
Please, my lord, I have a certificate, my lord, in the year 2015 itself. I placed before my,
Take that.
please, my lord. My lord, the respondent wife is a distant relative, knowing the fact that he's an handicapped, partial handicapped, my lord, she has married. It is distant relative, paternal side, aunt's daughter.
Please come. The present petition is filed, questioning the order of maintenance. That is 5,000 to the wife and 4,000 to the petition. Number one is wife.
Petition is filed with the wife. And
In the order, it says petitioner number one and petitioner number three. Who is number three?
3 is the son.
Who is two?
2 is the son, he is major, my lord.
Yes, measure. The court had granted 5,000 to the wife and 4,000 to the son. When counsel appearing for the petitioner submits that he is handicapped and is handicapped, and as per the certificate, is suffering with 75% disability, is working as a flower vendor on the road, on the footpath. As income is 10,000 per month. The court had granted 9,000 without any basis. It is submitted that the petitioner is not an able-bodied person. What did the wife do?
She has her own tailoring shop, but she has not disclosed in anywhere in a
It is
petition
that
or
the
affidavit.
wife is doing tailoring business, is having income out of it, which is not disclosed. Considering the same, they shall be stay of all further proceedings on the condition that he shall pay 4,000 by 5th of every month, and the arrears at 4,000 within 12 weeks. Same, this notice and summons to the counsel for the respondent and shall file a memo to that effect. If the memo is not filed by November 13th, on that ground also the stay granted by this court stands vacated. Next.
Cell number 9, preliminary reading B group. Sharvana S for petitioner. Venkatesh G.
For the petitioner, my lords, 1910, my lords, the mother had taken the child to the father. Father should answer, my lords, how the response was.
What happened? Where
Father
is your counsel?
Father is present.
No, where is? Oh, you appear for her.
I appear for the mother.
So how it went on?
Doesn't be satisfactory, not satisfactory, my lords.
Who?
Once it appears, they have spent only 40 minutes of time. And I think father itself, 10 minutes early, left the child. I don't know. She should answer. I didn't.
What
know.
happened? Come here. Huh?
I waited and I begged him like anything, but he didn't show his face also to me. They were sitting like in a L angle. He was sitting here and the mother is sitting next. I was begging them like anything, but she didn't turn at all.
What do you say? What are your instructions? Your instructions.
Good morning, ma'am.
What happened?
I didn't want to talk to him.
Huh?
Nothing. I didn't want to talk to him.
Why?
I don't like him. I only came so that my mom doesn't face consequences.
I think he requires some counseling. He requires some counseling.
Probably.
Whatever her feelings, she has completely transferred to him.
Probably, my lords, it was a long gap of 4 to 5 years.
No, apart from that, she has maybe, with all the, we cannot find fault with what has happened between both of them. But I think she quietly, with all her expressions and all, everything is transferred to him. Because what I had an interaction with him, I could understand that, but that's not right. He shouldn't be, and okay, if she's not happy with him, that is not, but why is she doing with the child? Where are they going for the counseling? Where are they ready to go? And it has to go on. Now, child, if the boy says, I'm not interested, court is not going to keep quiet. She has, both of them has, it,
They have to explore all the best possibilities.
we
and
should,
this-
there is nothing like possible. As far as the wife and husband are
But like
concerned,
there may be some
they're grown-up people, whatever decision they take, let them take. But as far as the child is concerned, this, I do not want to see my father. Father has not done anything to him. So if a mother is unhappy, that shouldn't be reflecting on the child. And if it is reflecting, that means the brought up is not going in the right way. So where do you suggest? And let mother, father, child, all the three of them go for the counseling. At the counseling place itself, let there be visitation.
Any centers?
To the family court will send. Family court mediator is there, and I think regularly they are there.
They have the cases. They are attending the cases also.
Yes.
Better.
So we'll send there. Let them interact. Let them place a report.
Please.
And I'm telling, like, once the report comes, and if they say that it is because of the mother's this is all happening, it will be viewed very seriously. That you please tell your client.
Please.
That's unfair. This court on 16/10/2025 has passed an order where granting the visitation in Orient Mall on 19/10/2025 between 5 and 6 p.m. in the presence of the mother. And the father is directed to transfer an amount of rupees you have transferred?
Yes. Yes.
An amount of rupees 2,50,000 to the mother as a part of the educational expenses of the boy without prejudice to the rights of either of the parties. As per the order passed by this court, the father has transferred an amount of rupees 2,50,000. It is submitted that on the day of visitation, the boy has refused to see the face of the father and he has not interacted with the father, and having no other go, even before the time, the father had to leave the place. The father, mother, and the child are present before the court. The child says, what is his age?
Now it should be 14 years.
The child says,
13, it is
Well and
13 running.
Huh?
13 years.
13, 13 years.
the child says that he doesn't like his father. He doesn't want to see his face, just for the sake that it would come on his mother, that she has not violated, she has violated the order. That's how he is before the court. Even when this court has interacted with the child, even on that day also, this court has interacted with the father, with the mother, and the father. But what all the mother's feelings towards the father, the same are reflected in the child. It is not at all good for the development and well-being of the child. Whatever are the differences between the mother and the father, it's a responsibility of both the parents to see that the child is kept away from all these negative emotions. In this case, it appears that the child is being completely is going, he is sailing with the mother, and what all the emotions that the mother has are reflected in the child. In these circumstances, this court feels that it is appropriate that the boy, mother, and the child shall go to the counselor, and this counseling session shall go on for 4 weeks. And after that, the report shall be placed before this court. Basing on the report placed by the child counselor, public counselor, this court will pass appropriate orders. In this case, in spite of an order that is passed by the family court and a contempt that is pending,
Yes,
Miscellaneous.
and a miscellaneous petition that is pending, the order that is passed in the year 2024 has not been complied with till today. The only reason for that, it is stated that the boy is not interested. It is also an admitted fact that the mother has never gone before the court from the last 1 year, asking the court to modify the order. This speaks volumes about the conduct. In that view of the matter, this court is passing the following order. 1. On 27th, 4th, 18th, and 25th, all the three of them shall appear before the counselor at the mediation center in Bangalore on all these days at 3 o'clock. At that time, the father shall be permitted to exercise the visitation for 1 hour after the counseling in the presence of the counselor. Once the counseling sessions are completed, the director shall place the report of the doctor before this court. Basing on that, the court will pass further orders.
Not still such time that the family court doesn't pass any orders on that, Mr. Inspector.
Till this process is complete, there shall be stay of all further proceedings pursuant to the order impugned dated so and so.
Grateful.
Yes.
Seal number 10, Sampath A. Petitioner.
Yes.
Here for the petitioner. We filed a miscellaneous petition seeking enhancement of maintenance, my lords. In the said miscellaneous, we filed an application for production of documents.
It's IAPF for the respondent.
Therefore, my lords,
IAPF for the respondent.
It is 10. Yes.
Production of documents, my lords, an application was filed. There, in
Where is
view
the
of-
order? Page number.
The order, my lords, is at page number 10, annexure. Start from page number 10 is the order sheet. The relevant portion is from page number 13, my lords. 15, my lords, it says the application is rejected. On the ground that, my lords, the respondent therein had submitted certain documents.
So what is it you want?
My lords, we've asked for documents, my lords, in the application is at page number 28. In page number 29, we've sought for certain documents. Now, my lords, they've produced documents of bank accounts. This bank account statements that they've produced, my lords, is not complete. They've selected and produced only 1 month's bank account statements, my lords.
Oh, as per the judgment,
lords,
they have to produce 3 years bank statement.
My
That
lords,
he has to do. If he's not doing, he'll face some music.
my lords, the reason for which I asked this particular statement, my lords, is because they've received some gratuity amounts, on superannuation, my lords. On retirement, certain lump sum amounts have been given to the respondent, my lords. That, my lords,
Please come to that. Let's see. Documents ought to be produced. Pension details of the respondent up to the date or record. Further, the court's observation is the pension details are reflected in the bank accounts. How much is it? Pension will not vary every day.
Yes,
so
ma'am.
that is not required. Then retirement benefits of the respondent. What is the answer by the court with regard to the retirement benefits?
That's page number 14, last
Once
page.
again, summoning the respondent also produced a recent SBI bank account extract to convince the court that he is regularly receiving the pension amount from the University of Mysore, and according even for the month of June 2025 and July 2025, he received pension amount from the University of Mysore apart from his SBI account statement, bank statement regarding credit of retirement benefits remitted to his bank account.
this, my lords, this was only the monthly pension amounts that is being
No,
granted, my
court
lords.
says about credit of retirement benefits remitted to his bank account.
My lords, if my lords may kindly peruse page number 38, my lords, annexed to
Service register of the respondent.
Yes,
Why
my
do you
lords,
want
there,
service
my lords,
register?
there, my lords, the date of
No,
retirement.
let's go to that. Why do you want service register?
My lords, the date of retirement, my lords, pertinent to note here is 30/9/2019. Therefore, on that date, my lords, in lump sum amounts might be credited to the respondent, my lords. That particular relevant portion of the
How
bank
not
details is
relevant
not.
for the purpose of deciding the maintenance?
My lords, the maintenance, my lords, have been granted at the rate of 3,000 rupees. I'm seeking for enhancement, my lords.
What is the pension that you are receiving? Yes, what is the amount you are receiving?
Lords, I'm receiving, my lords, 11,370.
How much?
11,370.
11,370. How old are you?
Lords, I'm now, my lords, retired. 2024, my lords, I was
Retired, my
63,
lords.
my lords.
Huh?
2024, I was 63.
What is the age of the wife?
She is 53 months.
From how long both the parties are residing separately?
They are residing separately since very long time.
How long?
I'm not aware.
Yes.
My lords, I think more than 5 years, my lords. I am not clearly aware of the duration of separation. But there's also the divorce petition. My lords,
When
there's
did you file the
another.
divorce petition?
In Mysore itself, my lords.
And when?
The divorce. My lords.
It's 2010.
2017, my lords.
2010 minutes initially minutes there was a MC petition filed by me. That was ex parte order that came to me minutes.
Filed by her? Or
No,
filed
I
by
had
you?
filed minutes
His
which came to
husband
me.
had filed it, my lords.
That came to be allowed ex parte minutes. Thereafter order 9 was filed minutes that came to be allowed. It's against which appeal is pending now. We are duration is pretty long time. And second thing, minutes there was a house.
What
which
is the maintenance that you have paid? How you have taken care of her?
3,000 was granted in 2011.
No. 2000, when is it granted?
Minutes in criminal miscellaneous 454 of 2011, 3,000 was granted. Now this petition is under 127 seeking for enhancement minutes from 3,000 to 20,000.
Basing on what you will have 20,000?
My lords, that is.
Pension is 11,000. How will he give?
My
How
lords,
can he give you
that
20,000 per month?
which is precisely why we sought for these documents, my lords, wherein in the service register of the respondent, my lords, details of the lump sum gratuity, superannuation and other aspects, my lords, that is granted to the respondent husband, my lords, will be mentioned therein. On receiving this particular documents, my lords, we'll get to know the actual amounts received by him. And on that basis, my lords, the family court may decide.
2011 till now, there are no children in the wedlock?
No, my lords, no children.
You are living, what do you do?
My lords,
He's practicing advocate.
Yes, my lords. But my lords, a perusal of this bank statement that they've produced, a portion of it also, my lords, show that the pension received is 27.
Income?
My lords, I'll seek instructions with regard to that particular aspect. My lords, matter may be passed to.
You are practicing, and he is a retired employee. His pension is 11,000. You want 20,000. Now is it? And you are living with 11,000
My
right from
lords.
2011. 3,000 from 2011.
My lords, his pension is not 11,000. My lords, the bank statement, my lords, that they themselves have produced. My lords, a perusal at page number 30 shows that he's received 27,000 towards pension, monthly pension.
Shall file an affidavit before this court. What is the pension that he is receiving every month? And also, what are the retirement, how much he has received as retirement benefits?
Please.
This is matter on 13th of November.
Much obliged.
Yes, next.
Till number 11, part and matter, Nehru MN for petitioner, Harisha is.
Appearing for respondent in this matter, my lordship. With kindly, they didn't serve the petition copy of the writ, my lordship.
What is this one?
Kindly peruse the
Three
order dated
occasions.
13/8/2025, my lord.
What are you doing from then without appearing before the court?
No, just pass out the matter at 2:30, my lordship. I will take the copy and took up the Xerox.
2:30.
So it's unfair on your part to make this submission. Last time your colleague was there, she didn't even tell that. And then I have read that 7-8 orders where your presence was not there. You can't even afford to ask this. Password.
List number 2, for orders matter, serial number 1.
For the petitioner's matter.
Yes.
Appearing for respondent number 4 and 5, my lord.
Yes.
This is the matter, my lord.
Yes, I heard you.
Yes.
I'll hear him.
Yeah, I wanted to point out the observations of the Honorable Lokayukta, my lord. I filed the report last time. Just point.
Yes.
Kindly take
Where is that
page number 80.
No, where is that order of the division bench where it is stated that all the matters pertaining to
Kindly
this?
see the statement of objections filed by them.
What is filed by them? What is filed?
Statement of objections, page number 13. Para 16 at page 12.
Page number?
Page 12, para 16 of the statement of objections that was filed. Mayor Malott, based on the aforementioned joint memo entered into WP number so was disposed of on 24/8/2012, the important observation made by the Honorable Court while passing the order of the.
Not able to find, where are you reading?
My lord, this
Paragraph number?
paragraph number 16, my lord, page 12.
Yes.
Starts with based on the.
Yes.
Yes, based on the aforementioned joint memo entered into the WP number disposed of on 24/8/2012. The important observation made by the Honorable Court while passing the order in the aforementioned PIL is culled out from the kind perusal of this Honorable Court. 4, 5, 6. Kindly come to the next page. They have extracted clause para 10 from the judgment. The registry is directed to place any writ petition, if any, filed in future pertaining to the project of development of housing complex for economically weaker section at Koramangala, Bangalore before Court Hall number 1, along with papers of the instant writ petition. This is their own extract, their own statement of objections, which was used to oppose an interim order when this writ petition was filed. Now, as far as the issue is, the land which originally belonged to the Bangalore BBMP was sold. About 1,512 apartments were sold with undivided interest for a sum of 30,000 to economically weaker section. The buildings, after putting in position, 2 blocks collapsed, and the entire lot were evacuated with a promise to rebuild. Without rebuilding, and there were a number of orders, various other orders passed by the division bench that they should rebuild the house. They did not. They went into a public-private partnership and entered into a concession agreement. This was also challenged in the order which I had extracted. In that writ petition, a compromise was reached because BBMP said that they had no money, government had no money. And it was decided to first develop this land for the apartments, build the apartments for the poor people, which was agreed. The condition in the concession agreement was that they first finish the project of EWS first and then only develop commercially. 2012 order, August 2024, 2012 order, to this day has not been done, because what has happened is the concessionary enters into an arrangement with a different builder, and they claim to have borrowed money and mortgage, the BBMP mortgages them illegally. This is what the finding of the Honorable Lokayukta at page 85 of the Lokayukta report, just now, which was passed on. We have given already a copy. Every petition I've given. I'll give you one more copy. I'll write. Give any other copy if you have. It was served, sir.
Not served is what my instructing counsel
It was.
said. I don't know. I don't want to say anything, but this is not.
I'm always fair. If I will give my copy, sir, I'll just read and give it to me. It's not that I'm depriving, but the councils are also representing other matters. Multiple copies have been given to them also. May I just take the attention of the Honorable, and I'll pass on my copy for you.
Thank you.
Page 85.
Yes.
Yeah, para 68. This is a Lokayukta report by Honorable Justice Vishwanath Shetty. The terms of the agreement makes it clear that the agreement consists of 2 parts. One, setting out the rights and obligations of the parties relating to construction of EWS quarters, and other the commercial component. The agreement mandates that MHPL, that is the concessionaire, to first construct EWS quarters. This is clear from Article 1.1 of the concession agreement dated 2/1/2012. And it is useful to extract the said clause set out in the Article 1.1, which reads as hereunder. Additional facilities shall mean all facilities with the concessionaire may build, provide, or procure in the area remaining in the site after construction of the EWS facility for commercial residential purposes consistent with good industry practice and in accordance with the agreement, and shall comprise BBMP share and concessionaire share. Now, what has happened is this concession agreement was in the consideration when the order in August 2012 was passed. Without the leave of the court, behind the back, they bring an amendment to this concession agreement and authorizing BBMP to mortgage the land. Now, that's the observation made at page 117 of the Lokayukta report. or before the page 82 would also be relevant. It is also recommended that when making a choice of a contractor, page 82, that is para 82, page 160, my apologies. Page 160, para 82. It is also recommended that while making a choice of a contractor to entrust the work of BBMP, the contractor who indulges in litigation should be avoided and there should be thorough background check before awarding the contract. If such a procedure is adopted, the construction work is entrusted to a reputed contractor who have necessary infrastructure, including financial support. The work can be got executed early and the scope for breach of contracts is very minimal. The facts of the present case shows that if the report of BBMP dated 22/7/2021 is taken into consideration, India Bulls Housing Finance Limited had sanctioned and the finance of 393 crores of and 357 crores for the entire project, of which 210 crores has been dispersed to MHPIL on the security of the property of BBMP, and out of the said amount, 24.73 crores has only been utilized for the construction of half-constructed 111 flats, while retaining misappropriating the rest of the money with it, this cannot be permitted. Further, the material on record also shows mortgage of 3.82 acres of land, which apparently appears to be 50% of share of MHVL by means of deposit of title deed in favor of India Bulls Finance Company. In this background, the question that arises for consideration is whether the creation of such mortgage by way of deposit of title deed is valid in law and whether it would fasten any liability on the property in question. Section 176(6) of the Karnataka Municipal Corporation Act 1976 provides for disposal of the property and interest therein by way of sale or transfer of interest can be done with previous approval of the state. It is useful to extract the same, which reads as follows. Disposal of property, 176, disposal of property and interest therein. 6, notwithstanding anything contained in this act, no movable property exceeding such sum in value as may be preserved shall be sold otherwise than by way of public auction. No property, whether movable or immovable, of whatever value, shall be transferred free of cost for any upset price. No lease or any immovable property exceeding 5 years shall be granted. No immovable property shall be disposed by way of sale or by other transfer except with the previous sanction of the government. 84. The reading of subsection 6 of section 176 of the Karnataka Municipal Corporation Act 1976 referred to above shows that it is not permissible for BBMP to create mortgage by the property belonging to BBMP and effecting the change of khata in favor of others without prior permission of the government. The question is as to whether such prior permission was granted by the government pertaining to BBMP to create the mortgage of the said property in favor of the India Bulls Finance Company by means of deposit of title. The government, by means of its notification dated 26/9/2002, has only authorized the BBMP to enter into a joint development agreement with MHIPL. The BBMP, by means of this letter dated 6/4/2015, had only informed the Additional Chief Secretary to Government, Urban Development Department, Government of Karnataka, regarding execution of the second amendment agreement dated 2/12/2014. Second agreement is after 2 years of the orders of the Honorable High Court. There is no material on record which prima facie shows that either BBMP or the MHIPL has obtained the prior approval of the government in terms of section 176 of the Karnataka Municipal Corporation Act for creating of mortgage or the rights of the MHPL in favor of India Bulls Finance Company. Therefore, it prima facie appears to me that fastening the liability of the property in question by creating a deposit title is
I've read the.
Yes. So, the fact of the matter is, we were totally kept in dark. Had an application, because the case was kept pending, matter is still there, the original case.
No, before that, let us see the prayer in this petition.
Yes, ma'am. Before that, I just would like to point out, on 24th of April 2023, 24, all before the notification 13.2 commenced, on 24/4/2023, an application was filed before the division bench for cancellation of concession agreement because of the breach and undertaking given by the concessionary. The concessionary
The pending matter.
in the pending matter, where an undertaking was given on behalf of the concessionary that the project will be completed within 18 months, which did not happen. I place a material. So based on that, we filed an application for cancellation of concession agreement. We were not aware of the mortgage at all. my learned friends' clients were not in the picture at the point of time. So we filed it, and because the vacation came up, immediately after vacation, we tried to move the matter. It was not getting listed. That in July, when we got this 13-2 notification, we again moved the matter, but that actually application was for cancellation of concession agreement in total. Once that is done, even this goes for it. But at that point of time, the bench observed without even at the time of mentioning, if it pertains to a surface, go to an appropriate bench. So we had no other go but move the application here. At that point of time, notice was issued and the objection was filed, wherein one of the grounds that was observed, the two grounds they said, the land does not belong to the EWS people or BBMP. It's 50% of the land now has been mortgaged. And they say that our land has not been affected. The question that I ask is, the consideration for putting up the EWS structure by the concessionary was to get the 50% of the land. And the concession agreement clause 1.1, as observed by the Honorable Lokaayukta, is that the EWS project should have been completed first. Then only the right to mortgage with BBMP, right to create a mortgage vests with the concessionary, and BBMP could not have given the permission. The second issue is that when the matter is under observation of the court and there's a direction, a periodic report has to be filed before the court. Contemporary petition was also pending at the point of time. Where was the necessity for BBMP to do? There are materials now comprehensive application is pending now, where we are challenging the root of the matter, the concession agreement, and we go back to the earlier division bench order where the government was directed to complete the construction. 1,500, they're all sweepers, my lord. 1,512 family members, basically sweepers from BBMP. They paid 30,000 rupees pledging their jewels way back in between 96 to 2004, and they were put in possession. Like matchbox buildings collapsed, 5 people died in the process. The government said evacuate them. And as I observed, pointed out, the very division bench has observed that once a registered lease cum sale deed is created, undivided interest is also passed on to the 1,512 families. If at all a mortgage has to be created, BBMP is not the absolute owner anymore. With respect to the entire land, the 1,512 family members also have a right. Not an exclusive, but jointly with BBMP. At the most, they should have gone before the division bench and said, listen, we don't have funds. Kindly permit us to mortgage. We would have opposed at the point of time. Now, in July, an application is, I think, advertisement is made under section 13(2). Then we come before this honorable court. The order passed by this honorable court to oppose their application for filing an objection. When we file an objection, a reply is given saying that you have no locus to question. Now, where do we go? Now, who is going to complete the project? BBMP says they don't have money, they are bankrupt. Then with what authority they can borrow? There are other materials. There are other materials to show that they have initiated proceedings before DRT. We are not concerned. We are challenged the concession agreement. We are complaining that the developer is a fraudster.
Please come to the prayer.
Yes, ma'am. To declare, that's page 34, my lord.
Yes.
To declare the mortgage deed dated 1/4/2019 produced herein and actually so and so in favor of the 6 respondents, Saman Capital, formerly known as India Bull, with respect to 3.82 so and so, to be declared as null and void. To quash the impugned notice under 13(2) of securitization, deconstruction, financial assets, so and so. Now, this notification now stands withdrawn. There is a related 13(2). Now they have withdrawn it because one of with Liberty saying that there's a technical error and they wanted to, they have withdrawn it in the section 14 proceedings. They have filed a memo saying that we have withdrawn it. That is because one of the allottees went before the DRT saying that he's an indignant person. Allow me to oppose this, and the land belongs to. The DRT granted initial stay, but later on dismissed it, saying that procedures under CPC has not been, order 33 has not been followed by DRT, and that it doesn't have the jurisdiction and pecuniary jurisdiction, it has to go to China. So that matter has been challenged in the section 32, article 32 petition before the Honorable Supreme Court. And notice has been ordered and they have entered.
This at page number 35.
Yes, my lord.
Prayer number 2.
Yes,
If once this prayer goes, how it will come before this court?
My lord, the mortgage deed still is there. That is the reason. The comprehensive matter of concession agreement is before Court Hall 1. And it is their own plea. They have extracted the order of the Honorable Division Bench saying that this matter, when it was argued, they said the matter should be agitated only before that. That is the reason any interim order was avoided. That being the case, all that I say is the matter is listed before the Division Bench on 5th. I've already commenced my arguments there.
Yes.
And my humble prayer is that let the matter be. If they have any opposition, any allegation they want to make at me, let them agitate before the same division bench. Well, I'm prepared to face that. Much obliged.
Let's see the respondents.
Can I?
Senior
I'll
counsel.
pass on the copy of the.
Appear
Please
for-
give a copy of the.
Please,
We represent whom?
my lord, I appear for the 6th respondent, India Bulls.
Appearing for
Yes, my lord,
respondent 2, my lord.
You appear for?
Respondent 2, my lord. BBMP.
Respondent number 3.
2, my lord. 2, BBMP. 2.
Yes. Who is representing the state?
I'm for respondent number 1, your lord.
I'm appearing for the respondent number 7.
Respondent number?
7.
I appear for respondent number 3, my
My
lord.
lord, appearing for respondent number 4 and 5, madam.
7 and 8 who represents?
Lordship.
8.
8.
Nobody is representing. Then
My
what
lord,
about
appearing
5?
for respondent number 4 and 5, 5, my lord. Appearing for 4 and 5.
Yes. And what about 3?
I represent 3, my lord.
You represent 3.
My lord, please come to. My learned friend said there's a joint memo. We are not even parties to it. Please have a look at, my lord, the joint memo which he says, my lord, where it was said that matter should go before the first court. In fact, my lord, they have filed an application before the first court saying this should go there. And my lord, no orders have been passed. My lord, matter is pending. Now, please come to, my lord, page 72 of the writ petition. I'll tell your lordships why. There was, my lord, a joint memo filed between the parties.
Who are the parties?
My lord, the employees
Yes.
and, my lord, the state and my lords may look at, my lord, page 4, serial number 4 at page 72. Economically weaker section, residential welfare association. And, my lord, all of them. What happened was there was a concession agreement. Concession agreement, my lord, was between the third respondent and, my lord, the BBMP, which, my lord, third respondent said, I will build a this building, my lord, for and on behalf of, my lord, all these employees. I'll give it to them. And, my lord, I'll, my lord, utilize, my lord, some part, my lord, for commercial development. That's what he said. That concession agreement, my lord, is
dated,
my lord, dated 2/1/2012. My lords get that at page 75. There's a reference there. What happened was, in this writ petition, my lord, 45915, an order came to be passed by this honorable court. At, my lord, this, my lord, if your lords look at, my lord, the concession, my lord, joint development, this joint memo, please come to, my lord, running page 75. Obligations to the third respondent. My lord, he has to, my lord, complete that building. Now, please come to, my lord, page 77, paragraph 4. That's more important.
77.
77, my lord. Paragraph 4. Petitioner original allottees of EWS shall abide by the following. Handbook of maintenance of common areas and respective apartments shall be signed by the respective allottees at the time of taking possession of the property, and this shall be adhered to strictly by the allottees. Terms and conditions handbook of maintenance shall be negotiated and mutually agreed. This, my lord, may not have relevance. Now, please come to B. Petitioners agree that out of 15.64 crore, my lord, acres of land, the total extent was 15.64. Out of 15.64 acres of project area, an area of 7.25 acres of land area earmarked for civic amenity, that is 0.78 acres, and a portion of the area earmarked for park, 1.10 acres, forming proportionate part of 10% of the project land of 15.64 acres shall be for the exclusive use of EWS facilities. Entire area of 7.25 shall be compounded and be for the sole enjoyment and possession of the original allottees. Parties agree that there shall be a 20 years non-alienation clause with the which prevents the allottees from alienating, etc., etc. Then, where is the mortgage? This, my lord, was accepted, and my lords may come to, my lord, the order passed by the division bench of this honorable court, my lord, by the then, my lord, Chief Justice, Justice Vikramjit Sen. Please come to, my lord, page 86. This was accepted.
Yes.
Where is that, this thing?
So 135, sir. Okay.
Yes.
The order passed, my lord, this honorable court, my lord, accepted that joint memo, concession agreement. Please come to, my lord, page 100. The order passed by this honorable court, it starts at 99.
Yes.
My lords may come to, my lord, paragraph 4, page 100. Concession agreement between respondent 2 and 3 shall remain in force except where the provisions are contrary to the agreement, exhibit C. That is, my lord, the joint memo, which has been duly signed by the petitioners. That is the EWS Welfare Association, which is the petitioner here before your lordship, and the counsel for the petitions as well as the newly implemented respondents on the one hand, respondents 2 and 3 together with their respective advocates. Now, my lord, please come to, my lord, paragraph 7 on the next page. We have carefully perused the terms, para 7 at page 101. Terms of exhibit C. So exhibit C is the joint development, joint my lord, memo, and are satisfied that it is the advantage of the allottees, original allottees of the subject lands. This writ petition is in public interest. Therefore, exhibit C, that's the joint memo, shall bind all the original allottees or 1,512 original allottees, regardless of whether they have signed exhibit C or not. Therefore, my lord, 7 acres, my lord, was kept apart for them. Balance, my lord, was, my lord, to be given, my lord, to the third respondent. He, my lord, borrowed loan from us. 200, my lord, nearly about 300 and odd crores they borrowed, my lord. Today it's about 500 crores. We are
We have not borrowed. We have not borrowed.
No, not you.
Lord, my learned friend may have some.
You said.
I don't want to say anything more. I can only say this. I, my lord, who has borrowed? The third respondent, my lord, who was to build, my lord, all this, borrows from us on the mortgage of, my lord, this property of 7 acres, my lord, which
And
he
what
has.
did he do?
He, my lord, does not build.
When was the mortgage?
Mortgage was, my lord, my lords get that at, my lord, running page 135. Annexure L.
No, part of that agreement empowers him to enter into a mortgage?
Yes, my lord.
Where is that agreement?
Please come to, my lord, running page.
Original agreement that is before the division bench.
Concession agreement, my lord.
That's before the division bench.
Yes.
It was accepted by the division bench.
Huh? Where is that memo? Lord, we have filed it along with the memo, I believe.
That is as amendment to the concession agreement.
But I asked, original.
Originally it doesn't. It's only in 2014 they create B and A back.
I think my learned friend may have some patience. Let me complete
I'm
it.
assisting.
Thereafter, my lord, my learned friend can. Otherwise, my lord, it will be like
First,
a
I
shuttle
want to
cock.
look at the
Please
original
come to my lord.
concession agreement.
Yes, my lord.
Yes.
Huh? Where is that? Memo dated? My lord must have it.
Memo dated?
What's the date?
It's given in the open court.
Huh? Given in the open court means in the date will be there. No?
Which memo? This one only.
You have an extra copy. My lord, can I pass on, my lord, if your lords?
Yes.
Do your lordships have, my lord, that memo?
So there is some memo, which is the page number.
My lord, it starts at page 2, my lord, concession agreement. My lords got that, my lord?
Letter of protest reply, that is one memo. Then the documents are filed.
There are documents, my lord, they have filed,
Document,
there are 4 documents has been filed.
what is the page number of that, in that document?
There is a concession agreement, amendment agreement, second agreement and demand.
Let's see the first concession agreement.
Concession agreement, my lords, you'll also get that at page 2. Now, my lord, in this, please come to my lord, running page 29. This concession agreement is accepted by the my lord division bench, as I pointed out. They said it binds them also. Para 5.2, my lord, or clause 5.2. Financing arrangement. What is this? You have filed it. My lord, I don't know whether your lordship's copy is readable.
Something it says arrangement
Why
as
don't you
would be
file,
necessary.
Whenever you file something into court, we must. So sorry, my lord, my profound about the concessionaire shall. I don't know, my lord, mine is also very, very hazy.
In my copy, it starts with arrangement as would be necessary to implement the project. How it starts?
But it starts with the concessionaire shall at its own cost dispose the expense and risk, make such finance arrangement as would be necessary to
So
implement
those
the
two
project.
lines are missing.
One line is, my lord, they have highlighted it and then xeroxed it. When we give to the court, we must be, my lord, fairer, make it, my lord, clearer copy, better than, my lord, what is with us. Sorry, I owe an apology to your lordship.
Yes, yes.
And then, which one?
So second amendment, 165 page.
And now please come to, my lord, page 165. There's an amendment.
So what does it say?
It says, my lord, he is entitled to, my lord, make financial arrangements. Now, my lord, there's an amendment. Please come to, my lord, page 165.
Next 65.
This agreement, original concession agreement is between respondent number 2 and respondent number 3.
Correct, my lord. That's right. Then there is an amendment. 165, my lord. Second amendment.
Please read.
165, sir. 165. This is 50. Start is 154.
It's 165.
Please, my lord. Second amendment agreement, my lord, dated 2nd of December 2014.
2nd of 2014.
Yes, my lord. My lords, now please come to page, my lord, 165. That is bottom, my lords, get the page numbers 9 of 11. In Article 13 of the Principal Agreement, immediately after 13.1, following Article 13.1.1 is added and is deemed to have been existed always. Concessioning authority consents to execute a mortgage in favor of the lenders or security trustee, acting for the benefit of the lenders of the project in the form of either an indenture or mortgage or a mortgage by deposit or title deeds at the option of the lender or security trustee, acting on their behalf over 50% of the built-up commercial area together with the common areas and proportionate undivided interest, right, title and interest in the site and additional facilities owned by the concessionaires, including EWS site area being concessionaire's share, in respect of which title would be transferred to the concessionaire upon completion of the construction in accordance with the provisions of the concession agreement. Following satisfaction of the requirements set out in the concession agreement, title over the concessionaire's share shall be transferred to the concessionaire through the registered instrument, subject to process.
What was mortgage now?
Mortgage, my lord, is
Where is the mortgage date?
135, sir.
135 of, my lord, the writ petition itself, my lord. All that, you must put it in one file, not. So sorry, my lord. We must make a convenience compilation. I don't know these.
Yes. So 100 and
135, my lord. Annexure N. Memorandum of entry of deposit or title deeds, my lord.
what is the extent?
So
Extent is, my lord,
145, 3.82.
3.82, my lord. That half of, my lord, 7.5. 7.25, my lord, is theirs only. We have
The
nothing.
extent is 15.
15. So only
Out of 15, 3.8 is
That's right.
mortgage.
because 7.25 is there, 7.25 my lord comes to this builder. Builder in turn, my lord, mortgages my lord 3.25, saying that he is borrowing the money from us for building this. And my lord, what has happened? In fact, it's our contention, my lord, before your lordship. These people have been set up by that builder to ensure that, my lord, I don't go against him. This is a simple thing. And mortgage, my lord, is created in our favor. We have paid them 300 crores. Today, my lord, it's about 500 crores of public money, but we are a non-banking financial company governed by, my lord, the Reserve Bank.
So you have mortgage was on
So 145 page.
1/4/2019.
Yes, ma'am.
1/4/2019, how much money you have given?
We lent, my lord, 393 crores, my lord.
393 crores.
Where do you get that?
What has happened from?
Nothing, my lord, nothing, not a penny has been paid.
Not paid. I'm asking the third respondent.
Lord, status reports have been filed in the PILs that have been pending before Court Hall number 1, my lords. BBMP has to issue us the construction plan to proceed. So therefore, they had to file status reports. So project is
So,
pending.
A
We are in the
concession
last-
agreement
we are in
of
the
the
last.
year 2012. That from 2012 to 2025, nothing has been done for various reasons.
No, my lords, we've built
But
almost-
only third respondent is benefited by getting the loan from the second, which respondent you are, second respondent?
I'm the sixth respondent.
No, second respondent.
Oh,
BBM.
No, BBM, my sixth respondent. So that's what has happened right from then to now.
No, my lords, we filed status reports. We've built, there's concrete and there's almost 3 floors built. Apartments have been
No,
come
for
up.
building 3 floors, it took 10 long years, 12 long years.
No, my lords, we filed necessary
But I think this
status
is a
reports.
case where all that relief they have sought has to be granted.
My lord,
Whether it's
the
sent to the
BBM,
first
the
court or-
Lokayukta report says register a criminal complaint against them.
Why it is not registered? You know?
There is also an earlier, kindly see,
There
my
should
lord,
be a criminal
there was
complaint
an
against the
application, there's a contempt is pending.
The BBMP.
Contempt
Whoever
is pending,
BBMP.
contempt is pending, and there is also another petition that came up before along with this, though it was not, wherein an application, a petition was made to directing the Lokayukta police to register the complaint. Unfortunately, I was told that petition, this was clubbed along with that. Unfortunately, that got dismissed, saying that the petition has no locus. We have nothing to do with that, however. The issue is, my lord, they had no right to kindly see their own document in concession agreement. What is the right of a lender? They have no right to mortgage. That page
So
62
what the
clause.
government is doing?
May I just intervene, my lord? Just a minute.
In fact,
9.5.
That I have seen is what the government is doing. A government is expected to
My
do
lord,
all the transactions. that
The
are happening.
developer, the concessionary is an MLA.
Hmm?
The concessionary who represents the thing is an MLA.
Third respondent.
Third respondent is an MLA. It's
The board, that's misleading.
at that point of time who has signed. I'll think. I can demonstrate very clearly. Yeah, then there's an inquiry conducted by the Lokayukta also. He is a sitting MLA. He was an MLA at that point of time too. And without going into politics, my lord, there's much to be said about them. Now,
How many are in number that the weaker section, the members?
1,512 families, my lord.
So 1,500.
We have been repeated. Contempt has been
paid
twice.
30,000.
Each one 30,000. The lease cum sale deed has been registered. That's what the Lordship Justice Vikramjit Sen has ordered, which I read on the last day. Just Vikram Sen, Justice Nagaratna's order very clearly says that how can the BBMP create even a right to enter into a concession agreement when they are not the absolute owners of the land, which I had pointed out.
Concession agreement is accepted by the division bench. It says, my lord, it
Please,
fits everybody.
the
including
concession
them.
agreement,
Not
they have
go before
played
the local-
fraud. The developer and the financiers. I'll just point out, Mel.
1 minute. When once a concession agreement is accepted by the division bench, if the BBMP or any other person have to go ahead and if they want any amendment to that, you are seeking amendment. You are not acting in accordance with the original concession
It's not-
agreement.
The entire thing, my lord, was in accordance with, my lord, the concession agreement and, my lord, in terms of.
In that case, why there should be an amendment? If you are going along with the concession agreement, there was no necessity to amend it.
Kindly see point 9.5.
Let him.
My
Yes.
submission to your lordship is, he is entitled, my lord, the finance, my lord, the building. For that,
Correct.
my lord, he has to,
Then
my
you
lord, borrow
don't
money.
require amendment. If the concession agreement number 1 is very clear, you don't require any amendment to
My
that.
submission to your lordship is, that, my lord, the 7.25 acres is theirs, no difficulty about it. Balance is, my lord, his. I asked myself this question, is, my lord, for the purpose of financing, is there, my lord, any bar under, my lord, even without the amendment, for, my lord, him to borrow money, my
The
lord,
fact
is the
is,
question
no,
for my
no,
lord.
it's not like that. It is in a public interest litigation, the concession agreement was accepted by the division bench. If you're doing anything, that it is binding on all the parties. If you're doing as per the concession agreement, and according to you, it is permissible, you wouldn't have entered into an amendment to that. If that amendment is entered, it should have been brought to the notice of the division bench.
Lord, my submission to your lordship says, that matter, my lord, was closed. Please look at, my lord, when was that entire PIL was closed in terms of the order passed by this.
Pending.
Please, my lord.
That's pending.
It is pending.
My lord, it is pending before, my lord, the division bench in another petition which they have filed. And in that, my lord, the matter is not being argued. What I, my lord, in fact, my lord, I must also bring to your lordship notice. In that written petition, my lord, before the PIL, they suppressed, my lord, the order of Justice Vikramji Sen. Suppressed, my lord, the entire thing. Therefore, my lord, they want, my lord, argue it here. No difficulty.
This is status report.
There,
Forget status.
they suppress, my lord, this order, and they, my lord, rely upon an earlier order, which has been, my lord, overridden by, my lord, this order of Justice Vikramji Sen.
No, coming to the reliefs that are sought before this.
Yeah, may I just intervene, my lord? Just 1 minute.
One minute. As far as the second, no, unless and until the second relief is there.
Yes, my lord.
That is the notice under 13(2) of the Surface Act.
That, my lord.
This court, you have withdrawn it.
I agree.
So nothing has to be
Absolutely,
decided by this
that
court.
would be my first submission.
That would be, there are nothing to be decided by this court. Then coming with regard to the other reliefs that are sought, whether all these done are contrary to the orders of the division bench or they are in consonance with the order of the division bench has to be decided by the division bench. Let it go
Leave it
before
to your
the
lordship,
division
I
bench.
don't want to say anything more.
Let it go because it is it's something
The
is,
thing is,
things are not appears to be
my
right.
lord, I entirely
Appears
agree.
to be
I
right.
entirely agree. I entirely agree. Only thing is, my lord, we paid the money thinking that, my lord, it is to be, my lord, built for them. And, my lord, when they come and say, oh, this is far, my lord, the EWS, economically weaker sections of society to be built, we, my lord, went out of our way to, my lord,
No,
pay.
both of you are the losers now. Now the third
That's what I'm
respondent,
saying.
third respondent is the one who is unjust enrichment.
Kindly see
Let it-
point
let it-
9.5, my lord. Just,
Let it go before. I understood.
just 9.5.
No, ultimately I'm doing
Not
what you
it
want.
says, what is the right for a financier? They have a duty to bring a substitution. That's provided there, not the mortgage.
Please come. I think all these filing rules should be changed.
Lord,
But all,
absolutely.
all the papers pertaining to the writ petitioner in one set of papers, all pertaining to the respondents to in another set.
No, not only that, my lord. Earlier, my lord, before the chief's court, they used to, my lord, put
Continuous numbers.
pagination.
That's what the practice.
Otherwise, my lord, what will happen here?
Follow.
We will say, look at this memo.
Which
look
10,
at-
which 20, we don't know.
Correct, absolutely.
It's case management,
And
they
the
should bring
main
it back.
problem is some of the papers are filed in the court. So there won't be any continuation numbers. They will give whatever number
No,
they
my lord,
want.
we'll, my lord, normally what happens is we'll have to look at the online website of the High Court. It will have the page numbers. Then, my lord, we will have to give, my lord, the continuous page numbers. It's our duty as lawyers. My lord, we must ultimately assist your lordship, my lord, in the best possible manner.
Yes. The present writ petition is filed, seeking the following prayer. The brief facts of this case are the petitioner before this court is an association of 1,512 allottees of the flat under the lease cum agreement in the year between the years 1996 and 2000.
Yes, ma'am.
2000?
2004.
Between 1996.
Lease cum sale deed, ma'am.
Lease cum sale deed. Between 1996 and 2004, all these, all the petitioners, the members of the petitioners, how it is arrayed as a the association.
EWS,
Association.
Karnataka EWS 1512 resolution.
Have paid an amount of rupees 30,000 to the second respondent herein, that is the
BBMP.
Bangalore Mahanagar Palike. It is stated that they have constructed apartments in as because of the poor construction, whatever the construction that is made is collapsed, and thereafter a writ petition is filed before this a public interest litigation is filed before this court, that is WPPIL
Earlier to that 11,912 of 2008.
11,000
9112 of 2008.
11,912.
912 of 2008. And by an order dated 12th of February 2009,
11912 of 2008.
government was directed to rebuild.
WPPL was filed. Where is the order?
That's ordered at page 64, Annexure C, my lord.
64. Was and by order dated 12th February 2009. The revision bench has passed an order observing that, taking into consideration the new construction is yet to come up and our erstwhile occupants are made to live in temporary sheds. The government pleader, they've directed the government advocate to take notice on behalf of the Housing and Urban Development Department and direct the Housing and Urban Development Department as well as corporation to take appropriate steps for sanction of the funds and to proceed with the construction and thereafter identify the erstwhile allottees and shall allot the same to them as expeditiously as possible. Later the concession agreement was entered.
Yes.
Later the third respondent has entered into a concession agreement with the third respondent dated
24th August 2012.
24th August 2012.
Which one? Sorry, madam. Concession agreement is dated. Give that. My
2nd of
apologies.
December, my lord. Sorry, 2nd of January 2012. My lords, get that at page 7 of my lord the memo. Anyway, my lord, it's 2nd of January 2012, my lord.
2nd of January, 2nd of January 2012. And as per the said agreement, that concession agreement, where is that particular clause in the concession agreement?
5.2, my lord. Financing arrangement or
1.1 also needs to be
No,
taken.
about what is the entitlement of these persons?
Entitlement of?
That with regard to that 7 acres of land.
That, my lords, get that, my lord, based on this, my lord, in the division bench order, my lord, of Justice Vikramjit Singh.
As per clause number 5.2, financing arrangement.
And that has to be read along with clause 9.5 regarding the financials entitlement. 9.5, lenders step in rights at 9.5, page 62, my lord.
9.2 at page?
Lenders step in rights, page 62. So the lender, when there's a default, can substitute a concessioner, not create a mortgage.
So now I have to ask them to read and write what it is. This also completely blurred.
Same thing, my lord.
Lenders step in rights.
It is totally blanked out and given to us.
So as for this concession agreement, it is for the third respondent to make the financial arrangement for construction of the same. It appears in the year on 2nd October or April of 2014? When is the mortgage date?
27 5 2013, sorry, 1 minute.
This concession agreement
Was challenged, madam.
was challenged before the, before this court and division bench of this court. What is, where is that page number?
That page number, my lord, is at page 69. Relevant page will be page 67.
$72, my lord, is that joint?
They filed WP number
67
4.
45915.
45915 of 2011 and and a joint memo was filed before the court. In that, the honorable division bench had in the said order,
24th August
it is
2000.
it is extract in that 4B, you extract 4B. A joint memo is filed and it is relevant to look at clause 4B of the joint memo, extract that. Then the division bench by order dated 24th July 2012 has observed that the concession agreement between respondent number 2 and respondent number 3, that is the BVM, that is the respondent number 2 and 3 herein also shall remain in force except where the provisions are contrary to the agreement. Exhibit C, which has been duly signed by the parties.
That's a joint memo, my lord.
To the joint memo, which has been duly signed by the parties. EWS Welfare Association and
7.
Yes, yes.
My lord, it binds everybody, including the.
At paragraph number 7 of the order, the division bench has observed that the writ petition that the division bench has perused the terms of Exhibit C, that is a joint memo, and are satisfied that it is to the advantage of the original allottees of the subject lands. The writ petition is in public interest and therefore Exhibit C shall bind all original allottees or 1,512 original allottees regardless of whether they have signed Exhibit C or not. Several of the petitioners was present in court and affirmed the submissions made by the counsel for petitioners and counsel for the newly added respondents. Then at paragraph number 10, the court has observed that registry is directed to place any writ petition if filed in future pertaining to the project of development of housing complex for economically weaker sections at Koramangala, Bangalore, before the court hall number 1, along with the papers of the instant writ petition. And accordingly, the court has also observed that the respondent number 2 has made available 5 acres of land in Iglur on Hosur Road for rehabilitation of 1,512 original allottees minus those who have accepted ₹30,000. Respondent number 2 undertakes to hand over possession of the site within 15 days from the date of order to respondent number 3, who shall immediately thereupon construct temporary transit sheds. At least this is done.
My lord, no water, no electricity, no thing. There's an application pending against. That's also there.
Sheds and other infrastructure for temporary rehabilitation of the said original allottees within 4 weeks thereafter.
The project should have been completed in 2 years, my lord.
This order is dated 24th August 2012. Then the third respondent has, so for second respondent and third respondent have entered into the particular clause number 5.2. There was an amendment. As per the said amendment, the third respondent can mortgage 3 acres of land.
3.2.
3.282 acres of land. And accordingly, he has mortgaged the land of 3.82 acres to the sixth respondent. And the sixth respondent has lent an amount of rupees
393 crores, my lord.
393 crores in the year 2000. What is the date?
2019.
In the year
2019.
When the sixth respondent has issued a notice under section 13(2), it is submitted that as the public interest litigation is pending before the division bench, while during the mentioning time, when they have made a mention that this is pertaining to a notice under 13(2), the division bench has directed them to move the matter before the court, which is having the roster of the surface under the Surface Act. As such, as there was no other option for the petitioners, they have filed the present writ petition. Then senior counsel appearing for the petitioner submits that after filing of this writ petition, the notice under section 13(2) of the Act is withdrawn by the bank with the liberty to file to give a fresh notification on certain technical grounds. It is submitted that right from 2012 till 2025, absolutely there is no development. And the third respondent had taken huge loans and they have not constructed anything. And as per the order of the division bench, when there is an obligation on the part of the third respondent to give the alternative land, to give the land and to see that the sheds are constructed.
The flats, my lord, apartments.
No. Alternative land.
That was given to only not all, my lord. Some of them are opted. Some are collected 30,000 rupees cash for rent because clause G says that it will be completed in 24 months. Only for 24 months.
Whatever now that is directed to be done, according to you, they have not done. They have not given the facility.
Yeah, it is not fit for occupancy. That is an application that is pending in the division.
That order was not complied with in its true sense. And in fact, they have filed a petition for violation of the
WP 18504 of 2022. It is clubbed with the original matter.
Already questioned the same, and it is clubbed with the PIL. That is clubbed with the PIL. It is submitted that when the concession agreement is accepted by the Honorable Division Bench, the amendment ought not to have been entered into. There ought not to have been an amendment to clause number 5.2 without the permission of without bringing it to the notice of the division bench. It is submitted that in fact the Lokayukta had taken note of the same, and the copy of the Lokayukta is placed before this court, wherein Lokayukta has clearly observed that without any permission, the BBMP has entered has amended the agreement
and created the mortgage.
In favor of the sixth respondent.
That writ petition, division bench order was not brought to the notice of the.
No, I'm only recording his contention.
And then, my lord, we were not made parties before the Lokayukta also.
Sixth, without the notice, without the BBMP has no authority. If the BBMP want to, the BBMP, if they want to alter the said agreement and permit the third respondent to mortgage the property, there should be a permission from the government.
They can give money.
And as per the report of the Lokayukta, no such permission is obtained by the BBMP from the government. It is also observed with the Lokayukta that the action has to be taken against the concern. The senior counsel submits that as all these things revolve around the lives of several people who have given an amount of rupees 30,000 and entered into an agreement with the BBMP as long back as in 2012.
2004.
Or 2004. As the PIL that is pending before the revision bench and which is going to come up for hearing on
The 5th,
5th of October.
5th of October.
5th of.
It's the 5th of November, my lord.
5th of November, this matter also needs to be clubbed with the, with the same, with the said matter, so that comprehensively the division bench would be able to decide all the issues that are, all the disputes that are pending between the parties. Next para. Then the senior counsel appearing on behalf of the 6th
Respondent.
The 6th respondent, which is known as the India Bills Housing Finance Limited, a non-banking finance company, who has lent an amount of rupees 393 crores way back in the year 2019. Nothing has been repaid and paid. They have initiated the proceedings under the Surface Act. The 6th respondent is not concerned with any of the concession, any of the terms and conditions between the petitioner and the BBMP. The 3rd respondent has entered into a, as per the loan agreement and as per the mortgage, the bank has lent an amount of rupees 393 crores. Even before the lokaयुक्त or at any of the proceedings, the 6th respondent is not a party to any of the proceedings and nothing is binding on them. It is submitted that now with all the interest, that amount comes to 500 crores.
560 crores.
560 crores, 60 crores. It is said that it is submitted that only the surface proceedings are questioned before this court at the behest of the 3rd respondent, by these petitioners. It's submitted that he also does not dispute the fact that 13-2 notice that was issued is withdrawn. Shall I record that you have also no objection to go it before the division bench or not?
Lord, I'm in your lordship's hand. Whatever your lordship feel,
No,
just
no,
one.
it is for your
I
submission.
will not say anything, my lord. When it falls from the court, I've never said no to my lord court.
It's not, it is what about your client? It's not about you as an advocate.
All right, my lord. I don't think, I leave it to your lordship. Whatever.
Can we record it that you have no objection?
Hmm?
My lord should please pass an order. My lord should please pass an order. My lord, speak on.
Yes, that's what I'm asking. It is submitted that this matter can be independently dealt with, and in none of the matters that are pending before the division bench, the 6th respondent is a party. And
My lord, 6th
They have been
respondent is a
implemented,
party.
madam.
I'm a party there.
oh, recently.
Yeah, we've been
Yes.
implemented.
Then remove
Yeah,
that.
she's allowed to change.
It is submitted that when the surface proceedings are initiated, as rightly as it is rightly directed by the division bench, it has to come before the court, which is having the roster, and as submitted by the petitioner, there are no grounds to club this matter along with the pending petition. What about the 3rd respondent? 3rd respondent is not even bothered to, he is the main one, not even bothered to come and appear before the court.
But I appeal for 3rd respondent.
Not just appearing means arguing also. The 3rd respondent, when counsel appearing for the 3rd respondent submits that in the pending matter with regard to what is the status of the construction and other things, a report was called for and they would be filing the report before the division bench. It is submitted that
The BBMP has already filed a status report on the last date of hearing before the division.
3rd respondent, it is submitted that already in the division bench has directed the BBMP to file a status report before the division bench. It is submitted that in view of the lapses in granting permission by the BBMP, the construction could, that's what she was submitting. They could not go ahead with the construction, and all these aspects were already placed before the division bench in their objections.
And contempt proceedings also, petition is also pending.
What is the role of this embassy Garuda Realtors fight?
My lord, this is where my learned friend accused us of colluding with now the issue is, we have done it, we have placed all this material, I don't want to waste the time.
No.
The
Who is he? What is the relevance?
Embassy Garuda has partnered with a concessionary, and Embassy Garuda owns controlling interest in India Bulls also. There is another matter now, it's being investigated by the Supreme Court.
Not correct.
That's the reason I said, there is a link I have established. This concession, and there is an affidavit that has been filed by the concessionary before the NCLT, which is also produced, wherein out of the whatever amount funded by them, they have directed 135 crores to be diverted to embassy. My lord, all that may not be relevant when this matter is going to be.
The petitioner has made a fifth respondent, and what about fourth?
That is sister company.
Third, fourth, fifth are all, my lord, the companies, my lord, which are to construct.
The fourth and fifth respondent.
Embassy Garuda Ventures, that is, they borrow the money, and Garuda, the third respondent gives a guarantee. The money does not come directly to them.
This court, having heard the land counsel and senior counsels on either side.
Embassy doesn't borrow money, my lord.
Embassy doesn't borrow, but Embassy Garuda, but the reality borrows.
Peruse the material on the court.
Prime borrower is Embassy Garuda.
Court has perused the reliefs that are sought, the report of the Lokayukta. It is so unfortunate that a matter which is where the weaker section, the people belonging to the weaker section, has paid the money from 1996 to 2004. Until now, the construction is not completed. Further, the third respondent has taken an amount of rupees 393 crores in 2019, even from 2019, as it appears from the submission of the learned senior counsel appearing for the petitioner. No much progress there's no much progress in by the third respondent.
The Lokayukta report says only 23 crores invested.
The Lokayukta, the report that is placed before this court of the Lokayukta, this court has perused the entire report. The Lokayukta has made serious observations with regard to the amended clauses of 5.2 in the concession, with the original concession agreement, and the permission not being obtained by the BBMP, from the government before mortgaging the properties. All these.
Lord, we are not made parties. That's also more very important.
Yeah, that you are not concerned. I'm Lokayukta thing is they're saying, because even if you're a party, whether the BBMP is required to take.
I would have been able to convince my lord the Lokayukta that my lord, it's in order. I would have been.
My lord, it's an NBFC. They would have done a due diligence.
Unless the permission is obtained, it's a government land.
Lord, once my lord, the order of this honorable court my lord, accepts it, that it can, he can borrow and there could be a lender, and lender my lord can.
Has found out.
It overrides my lord everything. That's what
has found out several certain irregularities in mortgaging the land by the BBMP. The manner in which the matter is dealt from 2012 till 2025 shows that this matter is of a serious concern and requires action, requires suitable orders from the court. The division bench has already in the earlier order has observed that whatever any writ petitions that are filed before this court pertaining to the
development of
for the development of this that's pertaining to this Karnataka
EWS land.
Residential Welfare Association that has to be placed before the division bench along with the order of the said writ petition. Considering the fact that the matter is coming up before the division bench on November 5th, and some other matters are also writ petitions that are filed by this association are tagged on to those writ petitions, to the PIL, this court is of the view that this matter has to be referred to the division bench for considering for adjudicating the disputes that are involved between the parties. Yes, the registry is directed to place the same before the division bench.
Much obliged.
Yes. Yes.
Cell number 2. Siri Rajashekar.
Lords,
For the respond number 1
This
bank,
is-
my lord.
notices, since it has come as unclaimed, it can be held sufficient, Lords.
There is a notice to the.
Yes, R2 and R3 is come with
respondent, 2 and
unclaimed,
3,
can be held sufficient.
returned with the postal shera as unclaimed amounts to deemed service of
Lords,
notice.
R4 and R6 also, Lords, note number 3 in the cause list.
Item delivered.
Yes, item delivered.
As per the postal track, the notice to R4 and R6 is delivered. Yes. Hence it also, all the 4 and 6 are served. Yes.
Lords, the question is as to whether section 5 application can be entertained by the DRT. Lords, this matter was argued in extenso before another coordinate bench. The coordinate bench took the view that Limitation Act is applicable by Justice Krishna Kumar. Then one division bench judgment came about which relied upon another Supreme Court judgment which dealt with section 18, holding that Limitation Act is not applicable. Then that Supreme Court judgment was again referred to in another order of the Supreme Court to say whether the same logic should be made applicable to section 17 or not, we will consider, and that matter is still pending before the Supreme Court. In the interregnum, there were other petitions which was filed before the coordinate bench. Lords, a very extensive hearing was undertaken before the coordinate bench. We have filed our written synopsis and the judgments. The matter stood adjourned to 1710, thinking that on 1710 the matter could be concluded only on the judgments. But the learned judge was in the division bench. Just waiting. I just pass on. This was the order passed by the division bench. After that, there are about 3 hearings where the.
And the act itself is very clear about what is whether the.
Not section. The prescription of section 45 days for filing of the application is with section 17(7) of the act. But section 17(7) says that proceedings will have to be conducted in accordance with the provisions of the RDDB Act. Section 29 of the RDDB Act says that Limitation Act is applicable. We had argued on the point that wherever a specific procedure is not provided for, if a jurisdiction is conferred on an existing court or an existing tribunal, because this is not a tribunal constituted under the SURFACE Act. This is a tribunal constituted under the RDDB Act with a specified procedure. When section 17 does not lay down a distinct procedure to be followed by the tribunal, but in turn says that you will have to follow the same procedure as per your constitution procedure, including the substantive laws, then the question is as to whether this would be done. Notice the coordinate bench took the view by referring to both section 29 of the Limitation Act, which speaks about, and also section 29 of the RDB Act, which says that Limitation Act is applicable, that section 5 applications should be entertained. But
So what has happened to the judgment of the Supreme Court with regard
Supreme
to
Court has not yet dealt with this issue.
land acquisition?
Pardon me, Lords.
As per the new act, land acquisition matters, what is the judgment of the Supreme Court?
Lords, judgment of the Supreme Court, Lords, is wherever the limitation is provided and an outer limit is provided for, then you cannot exceed. This is a settled law because we have it under the Commercial Courts Act. We have it under the Consumer Disputes Act.
The intention of the legislature is because these are all the debts.
Lords, now what happens when it comes to an appellate remedy, there is a distinct provision. Under section 18, it says we have to file an appeal within the prescribed period. There is a power conferred on the tribunal itself, that is the appellate tribunal itself, to condone the delay up to 90 days. Then the question came up before the Supreme Court whether Limitation Act is applicable. Then Supreme Court said Limitation Act is applicable, but section 5 is not applicable because there is a specific provision for the purpose of condonation of delay to the tribunal itself, because of which it excludes section 29. But section 14 continues to apply. This is the view taken by the Supreme Court. That is the judgment which was referred to by a division bench, which said that since the Supreme Court has taken this view, I will hold that Limitation Act is not applicable. Section 5 is not applicable. But before that, a coordinate bench had already taken a view that Limitation Act is applicable by a very exhaustive reference to all the provisions. The effect of section 17(7) was read as, as importing the provisions of the RDB Act, particularly chapter 3 of the RDB Act, into the provisions of the Surface Act because of the notion under section 17. Then section 29 of the Limitation Act was also interpreted to say that if the statute is silent regarding the condonation of delay, then this applies. Now this, is very extensive, I can say, that
No, now the division bench view is that Limitation Act does not apply.
despite the division bench, we brought it to the notice of the coordinate bench that division bench laid upon the judgment of the Supreme Court. That judgment of the Supreme Court itself is again referred to in another judgment of the Supreme Court, a subsequent order which says that whether this notion or the manner in which we have interpreted section 18, kindly pardon me, my lords, is also applicable to section 17 or not, is a question which we will decide. That means the division bench presupposed that section 17 had already been decided. But the Supreme Court itself clarified subsequently that we have not decided section 17, applicability of limitation to section 17. We will decide this issue. But when the matter came before the coordinate bench said that the pendency will not come in the way of deciding this question of law, we will decide this question of law. May I just pursue it? That's the order passed minutes by the coordinate bench. After that, can I just pass on this order minutes? The hearing is concluded virtually, just waiting for one of the hearings.
Could be had after 17 if that order is going to be.
Yes, this is matter 17th of November.
Yes.
It's coming up.
My
on
lord, one more.
I'm told, minutes, that the learned single judge has said that next Friday there is a likelihood of single sitting and the matter will be taken up.
Then we'll have it on somewhere on 13th of November.
Lordships.
My lord, one more submission. They have to approach the DRAT under section 18. Let them, whatever contention kept open. All limitation.
This is a
petition
which
is not
Only a question of law. Even if I go before the DRAT, the question is as to whether this Limitation Act is applicable or not.
Before DRAT
In
also
view
they
of the
can-
authoritative pronouncements, it still will have to be considered, minutes, by this honorable court.
Yes, yes. This is matter on 13th of November. It is submitted that the coordinate bench of this court has heard the matter and its orders are likely to be pronounced in the
Lords,
next.
the hearing is likely to be concluded next Friday.
Hearing
minutes.
is likely to be concluded. Yes, next.
Number 3, Basavanna, Madan.
Non-serving of the copy to the caveator. Who appears?
Basavanna.
I appear for the
Bhavna.
Please,
I will serve the copy on them.
please, my lords.
Hmm.
Let's, I seek for a short accommodation, my lords. A senior is out of station.
Yesterday I heard this matter.
No, my lords.
No.
It's a fresh matter coming for today.
This is matter on 6th of November. Is 4.
Please.
It is submitted that the papers are already served. Yes, next 4.
Number 4, Subba Reddy Kane.
Appearing for the
Petitioner,
petitioner, your lordship.
Yes. Why have you not, sir, complied with the office objections? Office objection shall be complied within a week. Default order is 5.
Till number 5,
Mashu.
A. Nagarajappa.
Petitioners in this matter.
What is your submission?
My lord,
What is
office objection,
objection?
my lord. Annexure A, my lord, it's a readable, my lord.
Annexure?
Annexure A, my lord, the letter of sanction, my lord, it is a readable, my lord.
Page number?
19. The relevant part is readable, my lord. That was my submission.
How much difficult it is to read?
My lord, the relevant portion was.
What you can read, the court also has to read. Please file the office objection.
Lords, I undertake to appear for respondent bank
One minute.
minutes.
The office objections. Or sustained petition shall comply with the office objections. What's your name?
Lords, case I Vardhan.
So and so. You have instructions to file wakalat.
Yes, my lords.
So and so submits that he has instructions to file wakalat. This is matter of the.
Lords, the
after office.
petitioner has been directed to
Monday,
file.
will be taken up on
to
Monday,
serve
my
a copy, my lords.
On the petitioner shall serve the copy of the
Please.
writ petition on the counsel for the respondent. If the office objections are complied with, list the matter on Monday.
Please.
Grateful, my lords.
Next.
Cell number 6, Naya. Cell number 6,
Yes.
Girish Kumar.
Lords, appearing on behalf of the.
Yes.
My lord, the entire case that is filed
is on the basis, what is challenged is magistrate's court order, and then declaring the account as NPA, which should not have been done due to pronate's judgment. And also the possession notice has been challenged in this case. The Lordships may kindly see. Just take your
It's a
Lordships
very
to
short
facts.
issue, my lords, if I can just put it in a nutshell. Lords, in respect of the MSMEs, wherever a loan is disbursed as an MSME,
Change the date.
Lords, the central government and the RBI, as a matter of policy to ensure that the MSMEs do not slip into NPA, have laid down an elaborate scheme. This was in the year 2015. Then the position of law was not fairly well settled, though in RBI versus the central bank versus RBI, it was said that these directions are mandatory.
Taken.
What's amount?
As of today, 33 crores, 47 lakhs is the outstanding.
Now it's an MSME.
It is something like some circular of the RBI that if it is above 25 crores?
2015 crores is the,
No, what is that limit? No, whatever the rules of the.
Lords, so far as MSME is
It is
concerned,
not applicable if the loan that is taken is above 25.
page 107 is the,
Is there some circular? You have it? I've seen it the other day.
then I'll have to ascertain, my lords, because I'm limited. Huh?
The other day I've seen that.
am not on that.
More
my
than
lord.
50
I am not
crores,
on
my
that.
lords. More than 50 crores.
No, whatever according to him, as per that act, it has to be followed or whatever it is. Now the RBI has given the guidelines saying that if the loan amount is
In excess of 20
is
crores or
above
25
so and
crores.
so, then those all will not apply.
That information I'll get it. my lords. I think bank will have that.
The
My lord,
other day I've heard it on. Not 1 crore, I think it is less than that. There are two.
No, what the basis of what I am going is, when pronate's judgment, which my learned friend is citing, it says that the bank has to figure out if it is an MSME account and all these things.
No.
The onus is also put on the borrower that he has to produce an affidavit and say that he is an MSME.
One judgment also it says that when 13-2 notice is issued,
The-
he is supposed to say that he is entitled for all this.
That is the latest Supreme Court judgment, wherein the Supreme Court now has clarified pronate's judgment. It clearly says subsequent to 13-2 notice is issued, if is an MSME, they have to come. In this case, they have not done that. What has happened in this case is, my lord,
When is the 13-2 notice?
13-2 notice is on 22/12/2022. 13-4 is on 8/3/23.
So they didn't give any response to that.
No, nothing at all. Subsequently, they have filed 2 writ petitions. They have gone, several litigations are going on. There are 3 writ petitions pending before this court. One is challenging the possession notice. There also, they don't take the ground of MSME. They keep quiet all along. And even at the time of sanctioning the loan, it was not an MSME account. Subsequently, they have registered it as MSME. They have not produced a single document to show that they are an MSME, and they have not
Page-
filed an affidavit. So
the
Supreme Court
loan
judgment
itself is disbursed.
Once the 13 notice is issued.
Page
to you-
57.
No, 13-2 notice objections.
Lords,
Or your
page
representation.
57, if your lords were to see page 57, this is the approval of the loan facility. In that para 2, your lords may kindly turn to.
No.
At page 57.
Before we go into that, when a notice is issued under 13-2, if you say that you are an MSME and you are entitled for any of the things that are given to you, any of the
Lords,
privileges.
because if that is the question, my lords, I'll definitely address this. The mandate, my lords, is under the scheme of the RBI circular is,
Considered by the Supreme Court in the latest judgment.
I'll just go through it, my lords, because
And
Is there?
the Honorable Apex Court
can
said.
be taken
when
up on Wednesday, my lords. If that is a position of law, I don't think I should say anything more than that, then I'll
13-2
be.
notice is issued. If you feel that you are an MSME and they have to follow a procedure as per that, you should bring it to their notice. And keeping quiet and later coming up is not correct.
No, it should not be. That's what happens up to Pronit's case. I fully understand this. Up to Pronit's case, the position of law was not yet certain about what facilities are extended, to what extent we are entitled to benefit. Everything was not clear. After Pronit's case declared that this is mandatory in nature and this process has to be undergone mandatorily, then, my lords, these grounds has been raised saying that no, because of Pronit's we are entitled. But if this position of law is again clarified saying that you should have raised it at an earlier instance, probably. I understand, my lords.
But more
Wednesday,
than
my
that-
lords, I'll
my lord,
just.
more than that, They've already got the benefit of restructuring. We have restructured that loan account in 21. They have taken the restructuring benefit. And again, there is a question of all this.
Let him go through the judgment. Wednesday will decide.
Amount is very huge. That's the only
How
reason.
much is the amount?
33 crores. Matter of fact, my lord, they have filed an essay.
Saturday, senior counsel?
Tomorrow, my lords.
Oh,
Yes.
tomorrow is Saturday.
Yes, yes.
Wednesday, my lords, Monday and Tuesday. Lords,
More
Monday
free
and
on
Tuesday,
Saturday,
I'm
my
having,
dear.
Saturday, my
Councils
lords,
are
is
also
a,
free on Saturday.
no, my lords,
because not-
Saturday is a very heavy day because of my commitments in other courts. Saturday for me is a very heavy day.
Wednesday.
Wednesday, my lords, I'll.
Wednesday
If that is the
part-
position, I don't think there should be
Is
any
Wednesday
difficulty, my
part
lords.
or-
I'll not.
But the senior counsel for the petition in part and the counsel for the respondent listed as partner on Wednesday. Yes, 7.
7.
Interim order may come.
Interim order only granted is extended till then. Yes.
Cell number 7.
I pay for the petitioner. The respondent number 2.
Hmm.
My lord, sir, sale notice was issued on 16/1/2025.
I-1 of 25 for dispensation with the production of the Annexure G. What is Annexure G?
Annexure G, my lords, is the notice dated 12/8/2025, page 43.
Hmm.
It
Is
is,
that?
it is quite legible, my lords. It is printed. It can be seen.
It should be legible to the court, not.
No, no, certainly, my lords. Your Honor, may just examine. In my opinion, I feel it is
Let's see.
quite legible. 43 page now.
Forty.
43.
So I number 125 is filed seeking dispensation of the production of the certificate copy of the Annexure G. I number 125 is allowed. Next, I number 2 of 25, typed copy of Annexure A and E. What are they? Let's see, A and E.
Annexure A, my lords, is at page 16.
Page number?
16, my lords. Even that is printed only, my lords.
Annexure 16, then
Page 33 is Annexure E.
you need to have a typed copy. We are not able to understand what it is.
33, my lords, I'll undertake to produce typed copy, my lords. 33, it is visible, but still, since it's a heavily colored Xerox, I will produce a typed copy.
The I number 2 of 25, seeking dispensation of production, the typed copy of Annexure A and E is filed. As far as A is concerned, is dispensed with, the petition shall file the typed copy of E. Next. Will after lunch? Will you?
Certainly, my lords, please.
Yes. Date order.
Sir, serial number 4.
ಮೇಡಮ್ ಈಗ ಯಾವ್ದು ಕೇಸ್ ಮುಗ್ದಿದೆ ಮೇಡಮ್? ಲಿಸ್ಟ್ ನಂಬರ್ ಮತ್ತೆ ಸೀರಿಯಲ್ ನಂಬರ್? ಅನಿತಾ ಅವರೇ, ಅನಿತಾ ಮೇಡಮ್.
ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ವಾ? ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ. ಡಿಸ್ಪ್ಲೇ ಬರಲ್ಲ. ಕಡೆ ಕಡೆ ಓಡಾಡಬೇಕು. ಸಾಹೇಬ್ರು ಲೇಟ್ ಅಂತ ಕಾಣುತ್ತೆ.
May pass it. Yes, that will call. Yes.
Case number 1, half hour matter. Case number 11. Case number 11, half hour in which one?
Appear for respondent.
Petitioner, please, my lord.
Yes. It's wrong. I'll see later. Yes. It's a repetition by the husband.
Yes, please.
Questioning it's an ex parte order and yesterday you were
Ex parte
arguing
order,
that during COVID time you couldn't appear before the court.
Yes, yes.
How much was granted?
10,000.
And what are the other grounds you are urging?
Other grounds that she living in adultery. And apart from that, the paramour, against the paramour,
The daughter has filed a
daughter has
complaint.
filed a POSCO case and that is pending for adjudication. And even in the, she has made a charge sheet witness. She has not supported to the daughter. She has supported to the accused. And totally she has, so my contention may be taken showing that I may be permitted to urge what are all the grounds that has been, I already filed a.
What are you paying or what have you paid?
I have not paid, I have not paid. I have not paid any amount.
Amount has been deposited.
The 1,50,000 rupees as per the order of this, as per the order of this honorable court, I have deposited before the lordship. So my humble contention before your lordship that I filed a detailed objection in the main petition. So one opportunity may be given before the.
My lord, here what happened? Earlier made several times has been given to the, several opportunity has been given to the
Like how it is
husband.
given to you here.
Husband, several opportunities has been given.
I'm saying like how it is given to you here before
Please,
this court.
Yeah. Here what happened?
Same manner.
No, my lord, here what happened, my lord. My colleague, I told my colleague, my lord, she unable to appear. Sorry, my lord, sorry for that. Yeah, my lord, kindly see the hardship in the trial, before the trial court.
It's
Annexure D, my lord.
He filed all the documents to
Personally,
show at that point of time he's suffering with COVID.
Husband was personally has appeared and pleaded for time, my lord. Several times he pleaded, he failed to engage the counsel for service. One fine day, my lord, the
Please tell the
learned
dates. What are the dates when he had entered appearance?
My lord,
So immediately after.
5/11/2019, my lord. 5/11/2019.
5/11?
2019.
Then?
First appearance, my lord. Thereafter, my lords, until passing of the interim order, my lord, he keep.
Interim order was passed when?
Yes, my lord.
Interim order was passed.
Interim maintenance order has been passed by the trial court, my lord. On 29/8/2021, my lord.
29/8/2000?
Sorry, 27/8/2021.
2021.
Please, ma'am.
Almost the entire proceedings were in the COVID time.
No, here, my lord, what happened? He keep appearing before the court, my lord. He was keep appearing before the court, and he pleaded for time for
What happened?
engage the counsel for service.
The arising out of an MC. What happened to the MC from 2019?
Now the stage is, my lord, evidence.
So let the court decide. All these years you are not.
But here what happened? He filed a writ petition before this honorable court, and he got stay.
MC, MC of the year 2019. Which court it is? Family court at Bangalore. I'll direct the court to dispose of this matter by December.
Yes, Minister. We are obliged for.
Interim maintenance, my lord, he has deposited.
No, with all these kind of allegations that he's making, it has to be. It's a case to be heard.
Oh, my lord, husband was set up a child for filing a POCSO case, my lord. Now she has.
Child is what is the age of the child?
It's 15 years. She has child now. See, our statement itself is she is a child.
Let the court decide. Yes.
See, the husband only set
Agreed
up
with
for.
the order passed in. Where is order? Where is order?
Annexure D, my lord.
71 minutes. Page number. 71, my lord. Page number.
Agreed with the orders passed in I number 2, whereby the court had granted maintenance of an amount of rupees 10,000 per month. The husband is before this court. Then counsel appearing for the husband submits that the order is passed. It is submitted that though he has initially appeared before the court, later as he was suffering with COVID, he couldn't engage the advocate, and the entire proceedings have happened during the COVID time. It is submitted that the wife is living in adultery. The daughter has filed a complaint against the paramour, and the same is registered on the provisions of the POCSO Act, and a charge sheet is also filed. It is submitted that if an opportunity is given, he would be able to lead evidence before the court. That how the wife is not entitled for maintenance. Then counsel appearing for the respondent submits that in spite of giving a reasonable opportunity, he has not contested the matter. Until now, he has not paid any amount to the wife. It is submitted that the order passed by the court is a balanced order, whether she is living in adultery and all other aspects can be decided at the time of after a full-fledged trial. And at this stage, the wife is entitled for maintenance and rightly granted by the court. Next one. Having heard the counsels on either side, there is a material on record. When who has filed the MC?
She on respondent filed.
MC,
Wife
has filed the MC seeking divorce on the ground of
dissolution of marriage.
Cruelty.
Dissolution of marriage.
Cruelty.
Seeking divorce on the ground of cruelty. In that the present IA is filed seeking maintenance. The wife, the husband, no doubt, has not contested, and admittedly all these proceedings have taken place during the course of COVID, and according to the husband, he is suffering with COVID. Further, the kind of allegations that are made where the wife the daughter has given a complaint against the paramour of the wife, and a POCSO case is registered. In these circumstances, this court deems it appropriate to give an opportunity to the petitioner to contest the case. However, this MC is of the year 2019. Instead of deciding on the interim application now, at this stage, the court shall decide this aspect along with the main case. Accordingly, the order impugned dated so and so is set aside, and the matter is set aside. Accordingly, the writ petition is allowed. The trial court, as this is MC of the year 2019, the trial court shall dispose of this matter by December 15th.
What's up?
My lord, 1,50,000 has been already deposited, my lord. Let
1,15,000 that is deposited before this court.
Before this court.
Before this
Court shall be transferred to the trial court. Yes.
For petitioner. So it's a sale notice, your honors will find it at page 16. The issue is basically that the auction which has been concluded in my favor has been subsequently cancelled, against which I am before this honorable court. Your honors will find the sale notice dated 16/1/2015 at page 16.
16/1?
16/1/2025.
It's an auction notice.
Sale notice.
Sale notice.
Then I participated in the auction. I emerged as the highest bidder, and the sale confirmation was issued on 28/2/2025.
28?
To 2025. That is the date of the auction.
Confirmation of sale.
Confirmation of sale. I paid 25%. Admittedly, no dispute about that.
How much you paid?
25% as on that date.
What is the amount?
The sale confirmation, page 20.
91 lakh.
What is the amount?
The reserve price, my lord, 1,37 lakh. Wherein 25% he paid.
And sale confirmation was issued on the same date. 75% I was supposed to pay the balance amount. Then in the meanwhile, while I was ready to pay the balance amount, the borrower, who is a respondent number 2 before this honorable court, files a writ petition before this honorable court and avails a stay. That petition finally came to be disposed of. So in view of this, bank did not accept my payment. The petition came to be
There is an interim order in the writ.
interim order in that writ petition saying no further actions.
So when was the writ petition disposed of?
31/7/2025. Sorry, 9/7/2025.
What is the order in the writ petition?
Order said they had already approached the DRT under a securitization application. That was already dismissed against them. Then they filed the writ petition before this honorable court. Writ petition was also dismissed, saying that you have an alternate remedy. Go before DRT and avail your appropriate remedy within 3 weeks. And for 3 weeks, that this honorable court directed no precipitative action should be taken.
Then the DRT has granted an order.
DRT has dismissed their petition. They approached the DRT, but no order of stay. Nothing has been sought so far.
So where is that? Where from you get that they are going to cancel it?
My lords, after that, then 9/7/2025, as I said, this honorable court disposed of the petition. So 3 weeks got over on 31/7/2025. I was ready to make the payment. They did not receive the payment, so I issued a legal notice saying that please receive my payment. Then on 8/8/2025 at page 33, they respond and they say that as abundant caution, we are still waiting if they take any further orders. But they show full commitment saying that your auction has been confirmed, nothing to worry about. We are giving our commitment that we'll sell the property in your favor. Then exactly 4 days after that, 12/8/2025, they cancel my auction and they say that no reasons are assigned.
In fact, my lord, what had happened, my lord? The second respondent, my lord, is a borrower. In fact, my lord, I conducted the auction. My lord, the petition, my lord, arrayed as a successful bid is not in dispute. I issued a confirmation. My lord, during the same time, my lord, the borrower approached this honorable court. This honorable court granted some certain interim order subject to certain payment, and he paid, and subsequently some extension, and he paid it. And thereafter, my lord, he paid the entire money, my lord, whatever, my lord, outstanding towards, my lord, to the bank. And my lord, which we accepted with all fairness. The reason is, my lord, ultimately is my borrower.
It's a residential house.
We have accepted. And my lord, in fact, subsequent to my lord, he given a representation to me. My lord, it's a matter of fact, my lord, we said that we have cancelled the auction. My lord, now
when he has paid,
my lord, he paid. My lord, after passing this subsequent to 9 July 2025.
After 9/7/2025.
My lord, my difficulty is
what was the stay that was granted by this court?
This was not to, no, my lord, further proceeding stay by the
condition.
Subject to certain condition which he complied initial conditions. Later it's got extended and
no. As per the interim order, what was he directed to pay?
My lord, I'll just point out, my lord.
Where
He
is
was-
that interim order?
Interim order is not produced, my lord. The final order, your honors will find it at page 25.
Any substantial amount is directed to pay?
Some amount was directed to be paid.
In fact, he
They,
paid.
in fact, bank made a representation before this honorable
No.
court saying that they had not paid the amount.
I understand. The query of the court is, by virtue of the interim order, what was the amount that was directed to be paid by this court? That I want to
My
know.
lord, today, my lord, I got the writ petition. I'm not able to secure the complete instruction.
Get
But my
instruction.
instruction is, my lord, he complied the interim order passed by.
Please get that. Why? Then what is the law on that?
My lord,
No,
I'll just point out,
when's-
I'll just point out two aspects. One is, my lord, now I have money below.
Keep it along with I have to correct it. I have to correct it.
It's law on the point, I'm producing a citation.
38, I'm aware.
Law on the point, I'll produce the citation.
Bafna judgment, my lord, I'll just point out in this way. My lord, I received the money from both. In fact, my lord, borrower also paid entire money in view of the, my lord, after passing in
No, I
order.
understand the fact.
But
that,
38, after 38, my lord,
paid the amount. He has paid the amount. The borrower has paid the amount. So what should happen to a sale confirmation?
in view of
That
the
is
judgment
been-
passed with recent, my lord, Supreme Court in the Bafna Motors, my lord, 13.8 is, my lord, after that, my lord, he can't redeem it, borrower. It is a position of law. Here the case, my lord, this honorable court shown certain, my lord, indulgence because it's a residential property. However, my lord, I leave to wisdom of this honorable court. If my lord may direct, my lord, to issue the sale certificate in favor of the auction purchaser, I am ready to do. Or, my lord,
Unfortunately, we are bound by the procedure,
then,
bound by law. We cannot pass any order contrary to the law laid down by the apex court.
I would on, my lord.
2024 judgment of the apex court has produced. It
That
will
is-
get-
May I make one submission, my lord? I'll produce the orders passed by this honorable court, but I'll also produce a judgment, my lord, regarding redemption of mortgage. I believe I don't have a case, but regarding one-time settlement, bank always had a right to settle the matter as a one-time settlement scheme. This is a case,
After
my
the
lord,
sale certificate is issued,
after the sale certificate is issued. I'll produce a judgment to that extent.
please. Yes, Mr. Smarta, on 6th of November.
And in this case, sale certificate is not yet issued. ma'am.
Only some confirmation.
No, confirmation of sale.
Only sale was confirmed.
Confirmation
Auction was
after-
confirmed.
After the confirmation of the sale.
One small
No.
update, my lords. After I filed this petition, this honorable court initially has granted interim order in my favor, directed me to deposit the entire amount before the bank, which I've already complied. So I've deposited the entire amount. In view of the orders in the same petition that your honor. is here.
Express, my lord, I have both the
That day they were not on record. He was not.
No,
they were not
that was
on-
an ad interim order. my lords. Ad interim order.
Ex parte
This
interim
honorable
order.
court directed me to
No,
deposit.
do one thing, keep both the monies with you.
So in fact,
My lord, may I make one submission, my lord? We'll give an undertaking that will indemnify the interest part, whichever the auction purchaser may incur in case he loses us.
Not acceptable from our end. my lords. We want the
But for
property.
me, my lord, it's my
The-
dwelling
the
house, the
council-
roof on my head.
the difficulty is this, my lord. In respect to the money paid by the, my lord, borrower, we appropriate towards the account for recovery of money. The money which paid by the, my lord, auction purchaser pursuant to order made by this honorable court, I kept it in FD. My lord, he is entitled for the FD rate of interest, those who are succeeds.
No, he'll ask for the 7% interest now.
No,
What-
not
Whatever
interest.
my lord decides.
Interest. No, my
FD
lords.
is a 2.5.
No, in fact, my auction, my lord, borrower is.
No, what is the FD interest?
My lord, maybe 6, it depends
6.5.
upon period.
The other day somebody was, you were only saying in other matter, 2.5, other than that.
No,
they're
no,
not
that's SB rate of
That's
interest, not
SB
FD.
interest. FD
FD, my lord,
6,
something, my lord,
6 to 7 at best.
6 to 7.
6 to 7.
In fact, my lord, he is undertaking saying that I'm going to pay, my lord, whatever
I'll
interest they
indemnify
pay
him
me.
for the interest amount, my lord. My only roof on the head will go if I lose the case.
How much
For him,
interest-
it's a business
How much
transaction.
interest you're ready to pay?
My lord, 7% is the FD rate, my lord. It's been 6 months now. I'll calculate it at the rate of 1 year and I'll give.
My lords, this is
Then counsel for the respondent submits that. The learned counsel for the respondent.
Number two.
Borrower, respondent number 2, borrower submits that. He has paid the entire amount. It's a residential, the property that is mortgaged to the bank is a residential building. Initially, as per the interim order in the earlier writ petition, which is filed by him, certain amounts were paid. And after the writ petition was disposed of on 9/7/2025, he has paid the entire amount. As such, the bank has cancelled the sale. Then counsel appearing for the petitioner submits that as per the law laid down by the fixed court. The redemption of mortgage is not permissible. Then counsel for the respondent borrower submits that whatever the amount that is paid by the petitioner, the auction purchaser, the respondent borrower is ready to pay the interest for the said amount. And also he submits that he'd come up with the judgments in support of his case. This is
Regarding
matter on 10th,
one-time settlement.
10th.
Interim order may be extended.
Interim order earlier granted is extended.
I'm grateful. Much obliged.
What is interim order on payment of the amount?
The entire effect of cancellation has been set aside because if this issue, if they return the original documents in his favor, then the entire matter becomes infructuous. So the cancellation has been
Order
stayed.
is, no, there is stay of that.
Stay of the cancellation and directed me to deposit the
notice,
balance.
which I said cancellation.
Cancellation notice has been stayed. Grateful.
No, the difficulty in granting ad interim orders in these matters is this.
That is
Without a notice to the bank.
Bank.
Well,
He's my auction purchaser and he's my borrower. Bank.
No loss is caused to the bank, Millards, because
It's not
both of
about it.
us.
Now you have paid the entire amount.
Certainly.
Now further litigation.
No, Millards, actually the law laid down by the Honorable Apex Court is clear. Once the sale confirmation has been issued, there ends the matter. There is no right for the borrower to redeem the mortgage at all. And without issuing any reasons, they can't mandatorily just cancel my amount.
There must be judgments contrary to that in the facts and circumstances of the case. That he will.
My lord, and he is not ascertaining his status, what right he has before this court. Sale certificate is said to be issued.
Either
My lord,
either of you have no right before this court. Your writ petition is already entertained and disposed of. It's
my
over
lord,
now.
my lord, I'm trying to protect the roof over my head. He's doing business with
We'll
the.
see, we'll see. Please come up with the judgment.
They shall come.
I beg to appear on behalf of. It's a matter, my lord, the DRT order, my lord, essayed before this honorable court. My lord, they say remedy under, my lord, section 80.
No representation for the petitioner. This is part of a dismissal on 18th of November. Don't extend if any interim order is there.
But in this case, I undertake to accept notice. In this serial number 9, my lord, I undertake to accept notice because earlier application, my lord, I assisted this one.
So and so submits that as instructions to
I am
file
seeking
wakalat in this matter.
stay of the operation of the DRT order and on the
What is the order
13-4
passed to
notice.
the DRT?
We have filed that the land they have attached is an agricultural land. Agricultural land has been exempted under 13(1) of the Surface Act. The order has been passed by the Honorable DRT where they have filed a suit for recovery of 12 crore rupees under DRT Act, under Recovery of Debt Act. After the order has been passed, they have invoked the Surface.
What order is passed?
That is to recover the money, 12 crore rupees, so and so, so and so.
Suit is decreed.
Suit is decreed. Thereafter, the respondents herein have invoked the Surface Act. My contention is that you have invoked the Surface Act against the agricultural land, which I have not mortgaged to you, number one. Secondly, the agriculture, not mortgage, my lord. Your Honor may kindly peruse annexure I,
Page number.
page number 168, my lord.
Do you have copy?
168. The schedule to the property is
Mortgage deed.
mortgage, simple mortgage deed,
No, I'm asking you, where is the impugned order?
my lord.
Where is the impugned order of the DRT?
Okay, impugned DRT order is annexure A, my lord. The background of this matter is like this, my lord. Once they have issued the notice under Surface, we have filed one writ petition before this honorable court. And when the writ petition was pending, they have issued this particular notice of symbolic possession, which was also challenged before this court in WP number 555 of 2024 and 1297 of 2024. Both these writ petitions have been together heard and disposed of, directing that the stay is granted till the DRT decides on the application filed or the application is filed before the DRT, challenging the very same notice in SA number 100, my lord. That SA number 100 was dismissed, stating that this is not an agricultural land. In fact, this is the agricultural land, my lord. I have produced the photographs, and inadvertently the DRT has held that the matter decided in Tata's matter is applicable, which is incorrect. I think it is ITC's case. That ITC hotel was running.
The applicants even admit to the mortgage of the scheduled property
Yes,
as
ma'am.
collateral security towards the credit facilities obtained by the borrower.
That is not the correct, my lord. I have not given this property. That is what I would like to submit your lordship. Kindly peruse the document
just
what
point
we
out,
have given this one.
I'll just point out. The first and foremost, my lord, my friend is relying in respect of the suit which I filed for recovery of money. That is, my lord, allowed in my favor. After, my lord, there are multiple rounds of critical DRT, DRAT, this honorable court, allowed in my favor, wherein, my lord, debt, my lord, availing the loan, and, my lord, all the notice which I issued, my lord, already affirmed by the DRT as well as, my lord, the matter pending for the DRAT. Now, my lord, there is no bar for the bank to initiate the action simultaneously or parallel in view of the transcore. I can initiate, my lord, I can file.
First on the point, whether this property is a, if you have.
It is not agriculture, it is not agriculture property, it is, my lord,
Whether it is mortgage or not.
mortgage to me. Mortgage deed we have produced. In
My
fact,
lord,
that is the
I
reason, my lord,
wanted
the
to
court, my lord, apart from that, I have one more submissions. This matter, my lord, in fact, this earlier occasion, this honorable court also, my lord, heard some of the petition. As well as DRT, my lord, gone into the matter in past and findings. No, there is a remedy under section 18. They're already before the DRT in some OA proceedings. These are, I'll just point out, my lord, section 18 for a moment, my lord.
This is a limited purposes, my lord,
not-
only
my lord,
for
the
the purpose
order,
of
my lord,
staying that particular
I'll
order.
just read the day, section 18 for a moment, my lord. Section 17, my lord, they're aside before this honorable court. Kindly see section 18 for a moment. Appeal to appellate tribunal. Any person aggrieved by any order made by the debt recovery tribunal under section 17 may prepare an appeal along with the such fee as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order debt recovery tribunal.
Will anyhow direct them to go? Now this petition is 2025. Only one clarification from the bank whether the property is mortgaged or.
It is mortgage, my lord. In fact, original application it is affirmed.
Often
And my lord, now merely
No.
He's denying it.
My lord, only orally they're denying the
No,
documents.
it is the proof then, my lord. Page number 160.
In fact, I don't have benefit of the, my lord, copy of the petition. Otherwise, my lord, I would have pointed out right.
You please come with
I
that.
will, my lord, tomorrow. I'll just assist this honorable.
Not tomorrow, my lord. I have
No,
two
my
other
lord,
matters
it's
in
not
the.
correct. It's not
in
the
the
first round.
If not
2
tomorrow,
weeks.
I'll not grant an interim order.
Okay, 2 weeks, my lord.
He wants to get with instructions. If it is tomorrow, I hear if I find
Why?
a point.
Because I have already committed in the other court.
Then it's fine. I'll adjourn it whenever you want, but no interim order.
My
What do you
lord,
want?
interim order is
No,
required.
no. Interim order will
More than
not.
100
Your Honor may kindly peruse, then take a
This
call,
is
my lord.
matter on
Kindly
29th
please.
of October.
My
You
lord.
have an alternative remedy to go before the DRAT. Now, on the only question that the properties which are not even mortgaged to
Mortgage,
the bank,
therefore, illegal.
according to them, it is mortgage. So he says tomorrow, if you want tomorrow, or else some other date you want. Without hearing that, I will not grant an interim
They
order.
would have given a copy of the petition. My lord, by this time, I would have taken from the bank. Since morning, I'm sitting in
My
this
lord,
court.
no, not like that, my lord. The other day when the matter came before,
Go into all that.
one second, my
When do
lord.
you want?
When the matter is came before, some other counsel's name was given here.
This is
So we
matter
went to them.
on 29th of October. So and so submits that he has instructions.
Second week, my lord.
No, November 12th.
Number 12, fine. Much up.
Point remote. Just
Let
tell
my
me.
learned friend not precipitate that particular
No,
thing.
I will not
Not
say
in one, I will
anything.
point out my lord, all the earlier rounds of litigation which is.
Okay,
before the
anyway,
court.
there is not mortgage with them.
But I'm telling you, if he comes up with instructions and if the court finds that your client has mortgaged the properties to the bank, which are now where the notice is issued, I will impose exemplary costs of 10 lakhs.
Yes, my lord.
10 lakhs on the, and for making, so if it is not, for making such a submission on the bank also.
Yes, my
Either
lord.
ways. The land council, the petitioner submits that they have not mortgaged the properties to the bank and they are agriculture properties. Land council with the respondent bank submits that the properties are mortgaged and he will get the instructions. In case either of the submissions made by on behalf of the bank or the borrower are not correct facts on record, exemplary costs of rupees 10 lakhs will be imposed. Yes, next.
My lord, kindly permit me to appear online, my lord. Serial number 8, my lord, I just missed it. Previous matter, my lord.
Even the council is not here. Somebody was appearing.
Hello, my lord, I am appearing for the petitioner, my lord, kindly permit me.
You have to serve papers on him.
My lord, I served the notice to my lord, learned counsel Vignesh. He was appearing earlier also in this matter, my lord.
Land council so and so submits that his instructions to file wakalat in this matter. Land council, the petitioner shall serve of the copy of the writ petition on the council for the respondent. List this matter on 29th of October.
Grateful.
Please, my lord, kindly. My lord, may I seek for first week, my lord? Seek for first week.
Yes, first week on 10th of November.
Please, my lord.
Yes.
Yes.
Your Lordship,
Yes.
I am before Your Lordship
Who is the respondent?
challenging this bank, State Bank of
Which is the
India.
bank?
State Bank of India.
Who appears for State Bank of India? You appear for State Bank of India? Please give papers to him. We'll hear him. Land council so and so submits, the land council is directed to take notice on behalf of the respondent bank. Land council, the petition to serve the copy of the appeal memo or the writ petition on the council. When do you want?
Next week, any date.
List the matter on 30th October.
Grateful.
Yes.
Obliged.
Lord, this is a surface matter.
I'm appearing for the
My lord,
respondent.
the
in
entire
this one.
payment has been made, ma'am.
My lord, I'll make one submission, my lord. This was like, my lord, when the matter was like, they challenged the outstanding amount was 23,55,075 rupees. And then, my lord, we decided to close it at the principal outstanding if it is paid within 8 weeks. They undertook to pay within 8 weeks, my lord.
When was
First,
that?
my lord.
When was that?
My lord, it was on like, they filed affidavit on 7/8/2025. And as on or before 28/8/2025, first installment were to be paid, that was paid. Thereafter, my lord, the second installment of 9,88,000 was supposed to be on or before 28/9/2025. They did not choose to pay. Now, my lord, on 21/10/2025, they have credited only 7,88,841. Still 2 lakhs is remaining, my lord. They have not made the entire payment.
So why should we interfere?
My lord, 2 lakh has been paid
Go
today.
on.
Today, ma'am.
My lord, we
2 lakhs has been paid today, ma'am.
No, what is this? Why should we extend for this benefit to your client? Just like that.
What has happened? Kindly see, my lord, the order dated 7/8/2025. ma'am. In this, my lord, 19,77,000 was agreed. My
that
lord,
is only if it is
so,
paid
my
within
lord,
8 weeks.
and 5 lakhs, my lord, was directed to pay to take possession back. That has been paid and possession is taken. And my lord, in the same order, 4,88,500 has to be paid on or before 28/8/2025. That also has been paid. My lord, insofar as the balance amount of 9 lakhs is concerned,
First
my
of
lord,
all, the interference of this court of this nature itself is a great thing for your client. And
Please.
your client can't afford to, not comply with the order and say that whenever I pay the amount, let the bank receive it. One-time settlement means one time.
20 days delay, 20 days.
20 days for that amount interest you take.
Please.
Pay the interest for
My
that
lord,
amount.
the understanding was, my lord, the benefit
But
will
in
be
fact,
extended only if
my
it is
lord,
paid within 8
the-
weeks, or otherwise they had to pay 23 lakhs, 55,000. Now they have not paid within 8 weeks, my lord.
In
For
fact,
after 8 weeks, how much time?
After 8 weeks, my lord, on 28/9, they were supposed to pay the second one. They have paid it on only 7 lakhs has been credited, 7,88,000 has been credited on
For the entire
21/10.
amount, which is after the order of this court, you pay the interest. Interest to the bank.
like 20 days delay.
Whatever
In
is
fact, the previous coordinate bench,
let's have the dates clear.
please,
No, you are supposed to pay
please,
by
19 lakh 77,682.
8/9/2025.
Please.
You are supposed to pay how much?
Lord, can I give the dates, my lord? 19 lakh 77,682 was the agreed amount. 19 lakh 77,682. My lord, this honorable court has said 5 lakhs has to be paid to take possession, which we have paid the next day. That is on 8/8/2025. 7/8, same day we have paid.
The
7/8/2025, and possession is taken. My lord, this honorable court also directed 4,88,500 has to be paid on or before 28/8/2025. 88,500.
Has to be paid by?
28/8/2025. That also has been paid, my lord.
Next.
In remaining half the amount, 9,88,000, this honorable court said that the court would pass the order if there is no no default. This court will pass order on remaining amount.
No, there is
No.
default.
It is the
If there is a
undertaken
default,
given.
that is what the order says, my lord. Insofar as balance payment, balance amount of 9,88,500, this court could pass just order if the petitioner does not commit default in paying 4,88,000. I have paid 4,88,000 also, my lord. And my lord, I had filed affidavit, my lord, I will not dispute, my lord, in which I said,
No, let's not complicate this.
Please.
You are supposed to pay 9,88,000 by what date?
my lord, by 28/9.
28/9.
2025.
How much you have paid by that day?
Please, ma'am.
Nothing was paid
I
on
paid-
that date.
I paid, my
Nothing
lord.
was paid.
When did he pay?
My lord,
By 28/9, nothing was paid, my lord. The second, what
Lord.
they had to pay 9,88,500, that was not paid. But they deposited on 21/10/2025, 7,88,000, 7,88,841 rupees on 21.
So for this.
Another 2 lakhs.
1 minute. For this, on this 7 lakhs amount, what is paid, which is supposed to be paid on 28/9, he paid on 21/10. Take interest on that.
Please.
Number one. Next, the remaining 2 lakhs from 21 till whatever date he has paid.
3 days.
For,
3 days.
3 days. That was also supposed to be
Lord,
from on
after
28/9.
21/10/2025, from in 28/9/2025 till the date he paid 2 lakhs interest on that, and on from 28/9/2025 to 21/10/2025 interest on 7,88,000, whatever that amount he has paid. Whatever is the interest from that day to that day, you take,
Please,
then
my lord.
only.
And
will,
2
will
lakhs,
pass.
they're saying they have paid it today, but we have to ascertain.
Can I make submission?
Yes.
Lord, there is some medical emergency in the matter. We tried to move the matter for extension. We tried to move the matter. My lord. We could not get it listed. There
What
was
you
some
have to-
medical.
what you have to
My lord, it is
understand
a residential house.
That is true,
Please.
but the problem is, court can't interfere in these kind of matters.
But
Court has interfered and given you the benefit because for various
My lord,
reasons.
let bank.
5 lakhs
My
we
lord,
have
let-
waived off, my lord. 5 lakhs we have waived
No,
off.
no,
We
no.
have given that
No, no, my
benefit.
lord, what is this? What is the wrong
Not
submission?
what is that wrong submission? I'm sorry.
My lord,
23 lakhs was the amount.
Lord,
23
let her
lakhs,
make submission. I'll make
55,000.
submission.
23 lakhs, 55,751 was the outstanding amount, my lord.
Now, we can't, first of all, if this court has to pass a final order, we can't pass order in this manner that whenever you pay, whenever you give, they have to take. What is the purpose of one-time settlement? they have calculated so many things and they have come out with a proposal that we will waive off this much, provided you pay the money within so and so time. You have failed to pay. What to do? You please make the calculation as per what I have said and come back. At the request of land counsel for the respondent to file the calculation on when the amounts are paid and what would be the interest for the delayed period. Shall file the same by 17th of November, list this matter on 17th.
Obliged.
List number 3, my lord. Serial number 1.
Yes.
I appear for the petitioner, my lord,
Yes.
challenging the maintenance award passed under 125 CRPC, my lord. That is 10,000.
How much was granted?
Total 13,000, my lord. 88,000 for the first respondent, 5,000 for the second respondent.
What is your income?
My income, actually, I'm a priest, my lord. I'm a pujari. I'm a pujari, my lord.
Pujari will also have some income.
Pujari, very less. Actually, my lord, there was no dispute at all, my lord. 2015, the marriage celebrated, and she started these type
We're
of.
not on that. Please tell the court, as per the statement of assets and liabilities, what is the income of the petitioner?
Income of the petitioner, my lord, it is total uncertain, my lord. He is a pujari and coming from an orthodox Brahmin family, my lord. The income is very uncertain.
But still he has to pay maintenance, even if he comes from orthodox family.
She is also working, my lord. She is working in various.
Those are all not the considerations, Mr. Counsel. Please tell the court what is the income. Uncertain is what is the minimum income he is getting.
Minimum around 10,000 he may take, my lord. And for that he has to look after.
Did you say before the family court?
My lord, your lordship may kindly see para number 14
Have you filed
of
your
the-
statement of assets and liabilities? Have you filed your bank account statement?
that is not forthcoming. Your lordship may kindly see para 14.
Notice to the
Para
respondent. Notice to the respondent. Yes.
Lord, interim
Yes.
order is very important, my lord.
Yes.
But husband's petition, my lords, challenging the order of the family court, my
How
lords.
much is granted?
20,000, 10,000 each to the child, my lords. Children, my lords, his age of about 24 years, my lords, the female. And she has completed graduation. I have incurred, my lord, all the expenses, education as well as maintenance, my lords.
Is this filed before the family court?
Yes, my lords.
Then even the major daughter is also entitled.
Of course, my lord, I have, my lord, the order is directing me to pay the maintenance as well as educational expenses of the children. Kindly see para number 16 and 17, my lords. The family court accepts that I have been making payment and I have been maintaining. Para number 16, notes, page number 21.
Yes.
There is no dispute regarding the ratio laid down by the Honorable Appeals Courts, but in the present case, admittedly, respondent has taken care of the petitioner and children by bearing educational expenses for a period of 22 years. This fact is admitted by the petitioner in her cross-examination. Therefore, it cannot be taken that respondent is negligent towards performing his duty as a husband and father. No doubt he has not paid maintenance to the wife and children after separation. However, he has paid the educational expenses even after separation. Then, in this context, after overall consideration of the facts and circumstances of the case, in the light of the evidence on record, this court opined that the petitioner is capable of maintaining herself. No need to award maintenance for her. However, children are pursuing their studies. Even as of now, they have attained majority. Their education is not completed. It is bounden duty of the respondent to maintain the children till completion of their education. Therefore, it is just and necessary proper to award
income.
Not 69,000. I am in defense service. Not as a clerk. 16 deduction would be nearly about 40,000. 26,000 is the take-home salary.
Why 40,000 reduction?
There are loans for educational purpose. I have availed loan. I am told that by my client that I have produced the exhibit R1 salary certificate.
Then counsel, for the petitioner submits that the court has granted 20,000, that is 10,000 each to the children. And he has been taking care of the educational expenses and the other needs of the children, which is recorded by the court. It is submitted that those salaries 69,000. After all deductions, his take-home salary is 29. And the court has granted 20,000 maintenance, and the loans are obtained for the purpose of education of the children. Considering all this, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 10,000, that is 5,000 each to both the children by 5th of every succeeding month, and the arrears also at the same.
Please,
Notice to the respondent. Yes, next.
Petition.
Yes.
If the father appeal, but petition has filed a maintenance bid,
What is the amount granted
20,000 per month.
to the wife,
Sorry, sir, son.
to the son?
Oh, yes, son.
What is your income?
When I was working, I am getting 70 to 80,000 per month. But from last 2 years, it's not working because he's suffering from brain cancer. He's not contesting the matter. It is the ex parte order.
Why you have not contested?
He's not aware of the proceedings. He's in the treatment. I have also produced the
When is the order passed?
12/6/2025.
12/6?
2025.
Where the court considers your, what your notices? The learned counsel for the petitioner filed her written arguments. The respondent remained ex parte. The matter was posted for evidence. Why you have not appeared before the court?
I am not aware of the proceeding filed by the petitioner, son.
Will the court says that in spite of service of notice, call
So
for the trial court
they have
records?
serviced the summons on my where I am working earlier, but as on the date I am not
Trial
working.
court records, we'll see. Yes, this is a matter.
I'm still taking the treatment for the cancer. Is the final stage.
This is matter on 10th of November. Notice.
Pressing A2 for the entry matter.
Yeah, that can only be granted on payment of amounts.
Proxy counsel in this.
If you're ready, then I'll grant stay.
What is it?
Yes.
Proxy counsel, my lord. On record counsel is not feeling well, he's went down. Take urgent.
This is a matter on 11th of November.
I appear for the petitioner in this case, my lords. This petition seeking enhancement of the maintenance
Notice
amount.
to the respondents. Next. Yes.
Needful done, my lord. Could I have taken?
Then counsel submits the needful is done. This is matter of service of notice. Is to.
Serial number 2 PF is paid, my lord, in the
It is
morning.
submitted that the needful is done.
There's
And
one,
deposit the amount.
my lord, I think it's my mistake, my lord. I was out of country during that time it has happened. My lord, if 2 weeks time is granted, my lord, I'll have it deposited, my lord. That's interim order, my lord.
Then counsel with the petitioner seeks time, 2 weeks time to file the acknowledgement for having deposited the amount of 50%. Yes. Yes. Who appears? Geeta Raj. Any objections or filed? I number 1 of 24 is filed to condone the delay of 578 days in filing the appeal. No objections are filed with the respondents for the reasons stated. Delay condoned on condition 3.1. In this also same. Next, admit post of final hearing, call for the DCR. 4.
Serial number 4. On behalf of HD Jagdish, I am representing. Connected one more matter is there, madam. Same arising out of Jagdish HD. Behalf of Jagdish HD.
One day you appear for the claimant, one day you appear for the
Sir, is some
insurance company. It's confusing for the court.
It's some inconvenience event. Somewhere.
List along with so and so. I number 1 of 25 is filed to condone the delay of 11 days. No objections are filed with the respondents. The delay of so-and-so is condoned on condition, list along with so-and-so. Admit post of final hearing, call for this year. Next. A week's time, default order. When council submits that the needful is done, list after service of notice. Next.
Petitioner mails. The memo for dispensation for R1 mails.
For R1.
Yes, ma'am.
Memo is for second dispensation of notice to R1 dispensed with. I have 1/24 to condone the delay of 346 days, condoned on condition. Next, admit post of final hearing, call for the PCR. Memo is filed second dispensation of notice to R1 dispensed with. Admit post of final hearing, call for the DCR. This also memo for dispensation of notice to R1 dispensed with. I have 1/24 is filed to condone the delay of 481 days in filing, condoned on condition. Case of death or injury.
Injury, my lord.
Yes, next. Memo is for seeking to withdraw the appeal. Memo is taken on record and appeal is dismissed as withdrawn. Yes, 11. Yes.
My lords, appearing for the appellant. We have the copies, but the opposite counsel is not there.
First of all, this process to R1.
Yeah, we have paid.
A week's time, you have already paid or you will pay? A week's time for within a week's time needful shall be done, or else appeal against R1 shall stand dismissed.
Case I appeal for the respondent.
1 minute. What is the non-filing of memo for having served copies of appeal paper? IA is so and so.
I have received.
12.
I appear for appellant
I
counsel.
have received.
No. I'm looking at in the first other
please.
matter. Who is R1?
Owner of the
Owner of
vehicle.
the vehicle, my lord.
Liability passing on him. the
Yeah, no.
Business.
List after service of notice.
Will comply within.
Week's time for complying with the office objections. 14.
Lord, I have not received the copies.
What happened to him? Why is he not coming to the court? No representation for dismissal. Next. Who is R? Let's see who is R1 and R2. No, 15. Mr. Pradeep is directed to take notice on behalf of the insurance company. Process, that is insurance company number 2. R2. The appellant shall serve the copy of the appeal memo on the counsel for the insurance company for service of notice on the needful shall be done as far as R1 is concerned within a week, or else appeal against R1 shall stand dismissed. Yes, Pradeep.
Yes, madam. Awaiting service. Deposited.
Deposited. The list after service of notice on R1 to R3, it is submitted that they have already deposited the amount. 17.
Not received the copies.
No representation.
Appear for R1.
No representation on behalf of the appellant. This is matter for dismissal. In respect of R2, Pradeep, I number 1/25 is filed to condone the delay of 136 days, condoned, admit post of final hearing, call for the DCR. List after service of notice. Yes. R1 is? What is, who appears for that? Yes, so and so is directed to take notice. Then it's completed. I number 1/25 is filed to condone the delay of 126 days. Condoned, the appellant shall serve the copies on the counsel for the respondent. Admit post of final hearing, call for the DCR. 21.
Uh,
19. Who appears for Royal Sundaram? Mr. Ravi Sampati is directed to take notice. Same, appellant shall serve the copy of the appeal memo on the counsel for the respondent, delay of 126 days. 19 it is not there, in 20 the delay is there, 126 days. Yes. 21,
Appear for appellate.
Madam, serial number 20, my lord. R2 is the Royal Sundaram Insurance Company, my lord.
already done. 21,
Please, I will serve the copy, my lord.
please serve on it. 21,
21 Tata Aegis. Any advocate may be.
Tata AG.
Yes, my lord.
SV Hegde Mulkan is directed to take notice.
Refer to local adult.
Show the papers on him.
Please, madam. Refer to.
The matter is referred to the local adalat.
My lord, it's a easier matter, my lord. I have deposited, my lord, 8,98,179.
So that what is that every day Mr. Ravish Penny's calculation, now a problem with your calculation also.
Here, my lord, they have calculated that, my lord, 1,625 again I had to deposit. That also I have deposited.
Then why is this?
Original certified copy of the deposit memo to be filed. What has happened, my lord? The deposit memo will be sent to the accounts branch of the company, my lord. Later on, my lord, will produce that one. For time being, my lord, we have produced the photocopy of the same, my lord.
They submitted that already. The deficit amount of rupees 1,625 as calculated by the registry is already paid. Yes.
My lord, not to disperse the amount, we have deposited before the MSCT, my lord. Liabilities under question, relationship has been disputed.
Stay is granted.
No, my lord. Lordship has to grant stay, not to disperse the amount deposited by the company.
Because I don't see the IA here.
But they have shown only submissions, my lord.
On what ground you are before this court?
Challenging the liability, my lord, on the ground of there is no relationship between the master and servant.
What is the finding of the court?
File missing. I read it yesterday only. I read it.
Because there should be, we should give them some relief also. To come with the file, to look at the file tomorrow.
Monday.
Monday. No, Monday we'll see, no notice now.
Please.
Yes.
Here I appear for the appellant. I am withdrawing liberty to take appropriate remedy. And
What is the appropriate remedy?
actually WP, I think, because the wife is not.
Office has raised objection with regard to the maintainability in view of section 173, one of the Motor Vehicles Act. A memo is filed seeking to withdraw the petition with the liberty to avail the appropriate remedy. Accordingly, the plea is
And
dismissed.
documents may kindly be.
Liberty. Huh?
Documents may kindly be ordered.
All the documents shall be returned to the appellant. Yes. Line number 1024 is filed to condone the delay of 608 days. No objections are filed with the respondent. The delay is condoned on condition.
24.1 also, my lord, arising out of
Same
same.
in this also same.
Okay.
Next 25, admit post of final hearing, call for the TCR. 25.
I appear for
Appears for
appellate.
the R2 is
KSRTC Corporation, my lord.
the IA number 1 is filed to condone the delay of 519 days. Same for the no objections are filed for the reasons stated, delay condone on condition. For R1 and R3 also you must be appearing.
Yes, madam.
For even the Mr. Rajshekhar takes notice on behalf of R1 and R3 also. Next 25.1 also 520 days delay condoned in this 25.1 also. Mr. Rajshekhar takes notice on for R2, R3 also. Then 25.2.
My lord, we have
IA
already
number
filed
1
our
of 25
appellate,
is
my lord.
filed seeking to dispense with the production of the CC of the judgment. IA is allowed for the present. IA number 2, Mr. Shiva Kumarappa TC takes notice.
Already Vakalat filed.
Oh, it is there. IA number 2 of 25 to condone the delay of 28 days condone. What is this stay?
My lord, stay of operation, my lord.
We'll see later. This is matter on 18th of November. Yes, 26.
Yes. 26, I appear for respondent number 2. Request for 10 days time minutes to file my objection, 890 days of delay minutes. The affidavit notes is not satisfactory minutes according to me.
All affidavits will be like that only. Anyhow, you are not paying the interest. What is that you lose? I number 1/24 is filed to condone the delay of 890 days condoned on condition.
Please.
Yes. Admit. Also final hearing, call for TCR. 329 days.
Appealing
same,
for response.
Condone on condition.
Subject to denial of interest, madam.
That's what.
President, in this case,
41 days condone.
on the quantum minutes, we are ready. 50,000 we are.
What is that?
It's a only quantum lordship we have discussed of.
Calculation around coming minutes, 45,000 minutes. Globally,
We'll call this matter at the end. We'll take up.
please.
Pass on. Yes, next.
384 days delay.
Time for- yes, sir.
384 days delay, madam.
Condoned on condition, admit
Maybe
final hearing.
recorded opposed, just recorded as opposed, that's all.
What is that?
Maybe recorded as opposed and maybe condoned.
Then counsel for the respondent submits that the delay is inordinate and opposed the same. However, considering the reasons stated, the delay is condoned on condition. Yes, next, admit final hearing TCR.
We have 75 days. Connected appeal.
Condone. Yes, admit final hearing TCR. Yes, 330, yes, who appears? Huh?
On 31, and connected matter, I appear on behalf of
Yes,
ICICI.
Mr. H.
PS.
Who? PS Jagdish takes notice on behalf of respondent number 2. Who are the other respondents? R1 notice has to go, I think, in this. No, but it is served. This also has to go. Notice to R1. Then in 31.1, I number 1/25 to condone the delay of 331 days condoned on condition. Yes.
This case I am for the appellant, my lord. The case of injury, appeal filed by
What is
insurance
this
company.
2,334 days?
In this actually, my lord, we have filed a review petition. my lord.
Notice
Stay is year number 3, my lord.
or served.
I am 1 and 2 served, my lord.
No, why should we condone this delay? You are the owner of the vehicle.
As on the date of acting, there is no policy, my lord. There is no motor policy. There is a PA policy. They have made party.
Who are you? The insurance company.
Insurance company, my lord.
You have contested the matter.
Yes, kindly.
Contested the matter. Why,
Yes,
why is this delay of 2,334
The
days?
insurance company filed a review petition, my lord.
When
Before
was it?
2016 filed.
When is the order passed?
2024, my lord. Yes, I have filed it.
When was the original order?
Original order 2016, my lord.
2016.
Yes.
When did you file the review?
Subsequent order, we have filed a review
The
petition.
review.
For there is no liability policy.
No, I said,
We have-
when did you file the review? Which year, which date?
2016, we have filed a review.
Immediately you file the review.
After execution, my lord. After award, they have filed a.
No. I'm not inclined to even look into it.
I am ready to deposit the entire amount, my lord.
This is matter. An entire amount, let them withdraw.
No, my lord, there is no policy, my lord.
19th. This is a matter on number 19.
Execution is there, my lord.
Yes, 33.
Appearing for appellants in 33.1.
Hearing for the appellant in the connected first matter, my lord.
You appear for whom in 33?
33, first matter, I am appearing for the appellant.
Yes.
That notice has to be ordered for the party.
Yes, Mr. So and so. In 33.1, how do you spell this name?
JS Halshetty.
For R2.
JS Halshetty is directed to take notice on
For
behalf
R2.
of the R2. R1 notice has to
R1,
go.
Sarathi is appeared, my lord, in for R1.
No, first, who is this? Shanta.
Sarathi.
Where do you?
Sarathi JM for R2. Is appearing, he may be direct to take notice for R1.
No, where do you find that name? Yes, Harati. Sharathi JM. Yes. Sharathi JM is directed to take notice on behalf of R1 or R2?
R1.
On behalf of R1. IA number in 33, 711 days delay condoned on condition. Next matter, 123 days condoned on condition. 89 days.
89 days.
Yes, admit post of final hearing. Call for the question.
For appellate matter, maybe refer to local after condone the delay.
310 days will waive off the interest.
Hmm?
Interest 310 days delay in filing the appeal.
I number 1025 to condone the delay of 310 days.
Refer to local adult.
On condition that they are not entitled for interest. Then counsel for the petition submitted the matter may be referred to the local adalat. Refer to the local adalat. Yes, next 35.
For second respondent, it can be
489
disposed
days
of,
condoned,
ready for disposal, 96,000 plus interest, except this period.
I agree, but only on two heads the trial court has taken the income 9,000. As per chart, 12,500 is to be taken. So on that basis, the loss of
It
income
has
is
to be
12,500.
or, shall I refer it to the local adalat? No. Shall I refer it to the local adalat or shall I pass the order?
Right now,
Pass over. Yes, 35 pass over. In this I number 1 of 25 to condone the delay of 499 days, condoned on condition. Pass over this matter. Yes, 36. Yes, 43 days condoned, admit post of final hearing, call for the discussion.
Refer the matter to local adalat, Milord. Refer the matter to local adalat.
This matter to the local adalat.
37, second respondent is the owner. Notice may be
Memo
dispensed.
is filed seeking dispensation of notice.
First
Part
respondent
two.
is Cholamandalam.
R2.
R2.
Dispense with who appears for Cholamandalam?
Cholamandalam means.
Who appears?
Yes.
Pradeep, Mr. Pradeep is directed to take notice on behalf of the respondent insurance council, company counsel for the applicant shall serve the copy of the appeal memo, 244 days condoned on condition. Admit final hearing TCR. Yes.
First
Nation?
respondent is the owner of the vehicle, my lord. Second respondent, National Insurance Company, my lord.
National?
Insurance Company. Kindly, first respondent notice may be dispensed with me.
Mr. B.C. Sitaramaro is directed to take notice on behalf of the insurance company. What about R2? R1?
R1 dispensation, my lord, I have filed it.
Our memo is filed seeking dispensation of notice to R1. 237 days delay, condoned on condition, admit final hearing TCR. Next. Mr. B.C. Shivanagoda is directed to take notice on behalf of the respondent insurance company. Who are the other respondents? Notice, the liability is on whom? Give that. Claim petition dismissed. Notice to the respondent.
I paper append, my lord. My lord, second respondent may be, notice may be dispensed with, my lord. First respondent, IFCO Tokyo General Insurance Company, my
Second
lord.
respondent. Mr. H.S. Lingaraj is directed to take notice. Then counsel for the applicant shall serve the copy of the appeal memo. Delay of 88 days condoned. Admit final hearing TCR. Next 41.
41, my lord, R2 is a HDFC General Insurance, my lord.
HDFC.
Shivanagoda is.
Ravi Sampati is not appearing.
Not appearing, my lord. Shivanagoda or Pradeep.
That's, Shivanagoda's name is also not there in this list. You appear, Mr. Shivanagoda?
Yes, my lord.
Shivanagoda is directed to take on behalf of
R1,
insurance company. What about
I will take notice R1, my lord.
Notice to R1, yes, 42. Yes.
Notice may be dispensed to R1, man.
This memo is filed seeking dispensation of notice to R1.
R2 is
Research
Sriram
by
General Insurance.
Sriram General Insurance, Pradeep is directed to take notice.
May refer to Lok Adal.
I number 1025 to condone the delay of 203 days, condone the request of the parties, matters referred to the Lok Adalat. 43,
R2 and 3 could be dispensed with, my lord. R1 is
memo is
Oriental.
filed seeking dispensation of notice 2 and 3. One is
Oriental Insurance Company, my lord.
Mr. Janardhan Reddy is directed to take notice
Please.
on behalf of the insurance company, and the land counsel, the appellant shall serve the copy of the appeal memo. I number 1025 to condone the delay of 241 days, condoned on condition.
Please.
Next. Admit final hearing. Oh, it is ECA matter. No admission. Yes.
Please.
Post this matter, the
BM,
final hearing. That's it.
respondent is BMTC. Dabali has filed connected appeal.
Yes, yes, Mr. FS Dabali is directed to take notice. List along with, give the
Yeah,
number.
7017 of
Yes, list
23.
along with so and so. Next 45.
My second disappointment notice may be dispensed with, my lord.
Yes.
First disappointment, Liberty General Insurance Company, my lord.
Notice the second respondent is dispensed with. Who appears to the Liberty General
And
Insurance?
Pradeep is them, my lord.
Pradeep is directed to take notice on behalf of the insurance company. I have 1025 to condone the delay of 182 days, condoned on condition. Yes, next 46. Yes,
I have paper appellant counsel, my lord, kindly, first disappointment on notice may be dispensed with, my lord.
memo is filed seeking dispensation of notice to R1. Dispense with what is it, which is insurance company? United India. Mr. L. Srikantra is directed to take notice. Then counsel the appellant shall serve the copy of the appeal memo. I number 1025 to condone the delay of 79 days, condone, admit post for final hearing. Call for the TCR.
For the second respondent.
There is Rangegowda. Admit post for final hearing. 47.1, a week's time for paying, within a week's time, needful shall be done, or else the appeal shall stand dismissed against first respondent. He has not served the copy on you.
Yes, my lord, I have filed wakalat in both the cases.
Yes.
Served.
48,
For third respondent, death case can be disposed of the other side.
end of the list. But where is the counsel?
Is not.
Call
Tomorrow,
the counsel.
tomorrow, please.
Tomorrow, this is matter tomorrow. Yes, 49.
Petition was dismissed, my TCR is necessary.
But this what, admit post for final hearings, call for the TCR. 50.
50 for respondent number 2, ma'am.
For the first respondent, my lord.
Admit post for final hearing, call for the TCR. Yes. Admit final hearing, call for the TCR. 52. Harini Shivananda, admit final hearing, TCR.
I am for appellate in
Yes,
this case.
Pradeep, what is this case?
It is a consortium and not has been awarded. That is the.
What is this case?
Consortium
It's case of
to-
death, my lord. The income, as per
Yes,
chart,
this
my lord, it
also
has been
will-
considered.
Will this pass out? Yes, next 54.
That appear for the appellant,
Hmm.
filing memo for dispensation of notice to respond number 3.
Take that memo is.
The
filed in
appeal is on
dispensation.
quantum, my lord. The major.
What is the amount granted?
12 lakhs is granted. We'll deposit around
Admitted is around?
12 lakh 62,036. I'll deposit 6 lakh 50,000.
No, no. You're disputing the quantum on what account?
My lord, married daughters are claiming compensation. The tribunal has.
What is the age of the daughters?
One 40 and the other is 35. And the father was yet around 59 years. Court has deducted 1/3.
It is, then counsel for the applicant insurance company submits that the court has considered the married daughters who are aged 35 and 40 as dependents, and 1/3 has been deducted. In fact, the court, otherwise also 1/3, the wife is there,
Wife is not there, my lord.
wife is no more.
Wife is not.
Is deducted. It is submitted that the court, without considering the case of the insurance company, has granted the compensation of an amount of 12 lakhs.
12 lakhs, 62,036.
62,036. Considering the submission, they should stay on the condition that they shall deposit half of the amount within 4 weeks, and on such deposit, the respondents are at liberty to withdraw. Notice to R1, memo is filed seeking dispensation of notice to R1, notice to R3, and notice to R1 and R2.
Please.
Yes, 55.
R1 could be dispensed with, my lord,
Oh, it's
Shriram.
filed for dispensation of notice to R1. Then
R2 Shriram, my lord.
Shriram General Insurance.
Shivanegowda.
Mr. Shivanagowda is directed to, only, for this, only 4 counsels are there. Mr. B.C. Shivanagowda is directed to take notice on behalf of the insurance company. So it's now the process is, the
Yes,
procedure.
ma'am.
Admit, post of final hearing, call for the DCR 56.
I'm preparing for appellant in this case, Your Honor.
Hmm?
Claimant appeal, man.
Liabilities on whom?
Liability is insurance company R1, Your Honor.
Then R2,
R2 is the owner of the vehicle.
Then
Can you
file a memo.
dispense? Yes, my lord.
which insurance company is that?
Bajaj General Insurance. B. Pradeep.
HR Renuka is directed to take notice on behalf of the respondent insurance company. Counsel shall serve the copy of the appeal memo. Memo is filed seeking dispensation of notice to R1.
R2.
R2, dispense with at the risk of appellant, admit post of final hearing, call for the DCR.
Lordship, quantum for dispensation, I filed memo for dispensation of second respondent. The tribunal,
Memo filed seeking dispensation of notice to the second respondent.
the doctor has assessed 12.5% is whole body disability. In spite of that, the tribunal added the 40% future prospections. 1,50,000 is the difference amount, my lordship. I am ready to deposit balance amount, my lord.
What is the
Total award
balance?
amount is 7,19,000 rupees, my lordship. Out of which 1,50,000 have to,
So it comes to around 6 lakhs.
6.5 lakh I am ready to deposit.
It is submitted that though the disability is 12%.
12.5.
12%, the court has granted future prospects at 40%. And on that ground, the insurance company is before this court. Considering the submission of the land counsel for the appellant, it shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 6,50,000 within 4 weeks. And on such deposit, the respondents are at liberty to withdraw. Notice notice to the respondent. R1. Mr. Dabali is directed to take notice. Only one respondent. Mr. Dabali is directed to take notice on behalf of the respondent. Calls for the appellant to serve the copy of the appeal memo. Admit final hearing this year. Yes.
This insurance company appeal challenging the pay and recovery order on the ground that the accused has consumed alcohol that has been established before this honorable tribunal. Despite of it, the tribunal has passed a pay and recovery order that has been challenged.
No,
Because-
charge sheet is filed against the.
Accused itself under section 185 of MB Act
Hmm.
for having consumed the alcohol. It is pursuant to the
No,
amendment.
that is the driver of the opposite vehicle.
Drivers of insured vehicle.
That's what, insured vehicle.
Yes, ma'am.
So what third party will do?
Because it is subsequent to the amendment act. Because that is as per the amendment act. This is also one of the established defenses, statutory defenses available to the insurance company.
For the petition, appellant submits that the accused has consumed alcohol, and in those circumstances, there cannot be an order of pay and recover. Considering the same, there should be stay of all further proceedings. And the conditions, same, all other conditions, but no, nothing to withdraw. Yes, no
Yes,
withdrawal.
okay.
Yes, next. Yes. Oriental Insurance Company, who appears?
Rajendra Hegde.
Huh?
Rajendra Hegde. Rory.
So submits that, so and so is directed to take notice on behalf of the respondent insurance company. Ready? Ready. Serve the papers on him. Then counsel shall serve the copy of the appeal memo on the counsel and list this matter on 4th of November. United India Insurance.
I'm for appellate in this case, my lord. It is United India Insurance
Who appears?
copy.
Mr. Ravish Vani is directed to take notice on behalf of the insurance company. Serve the papers on him.
Yes, my lord.
Mr. Yes, same date like in the other case. Yes, 62. Yes,
Case of death, my lord.
very specific. Ready?
Only simple, my lord.
Can you,
This,
teacher is required.
No, my lord, in this case, the income as per the chart has been considered.
Hmm.
My lord, friend grievance is that my lord, he has produced a SSLC marks card and he was
picture
did a
completion, my lord. Certificate produced, my lord.
IT certificate.
Skilled worker.
Skilled worker,
skilled
but they have
worker.
not established any material. There is no
Skilled worker.
material except that, my lord. There is no material to show that he was working in any company or any firm or anything.
What is the age of the deceased?
31 years.
31 years, my lord.
How much, what is taken, what is the income taken?
15,500 as rightly considered.
500, my lord.
That's the only ground.
Only ground, my lord. But I have produced the exhibit 19, my lord. Course completion certificate is there, my lord. But tribunal has taken only chart income, my lord.
No, that shows that
Some, he was a skilled worker, my lord.
It is, my lord, but they have to establish that,
Claimants
my lord,
are
he was
wife,
aged
my lord.
about 31 years. My lord. Just now, he has not completed that course, my lord. If he is working somewhere else, my lord, there should be some document. my lord.
No,
2007 to 2009
the
completion.
skilled worker. So he'll do a job of that nature and he is, or he is capable of doing that kind of a work.
But they have not established that, my lord. Whether where he was working.
We'll take another 2,000.
My lord.
Claimants
Take another
are
2,000.
wife, minor children and
I'm
parents.
saying we'll take another 2,000.
Please.
15,500 is what is taken.
Yes,
We'll take another 2,000.
Please.
What do you say, Pradeep?
2,000 is on here side, my lord. Because, my
What-
lord,
what is the amount for the
15,500
skill-
for the skill labor.
I'm saying for that particular period, for the skill labor, how is?
Skill
what is
labor is concerned, my lord, 569 rupees is there, my lord.
500
69 rupees
into,
into 26 days, my lord.
how much is coming? $14,794 it's coming. How can it be?
That's what, my lord. Chart income is
So,
chart
chart
income
is-
is more, my lord. X, my lord. Exactly, my lord. Chart income
That's
is more.
why, looking at the chart income, if it is 15,500,
I
as
just
on-
now opened that notification also. So far as skill labor is concerned, I have opened the notification. The skill labors, as per the minimum wages, 569 rupees. That's what, my lord. It is more than that chart income. Chart income is more than that minimum wages.
so now the unskilled labor is getting more income than the skilled one.
Unskilled is very less, my lord. Little less.
Wait, no,
560.
from
It's
the
a skill
chart.
labor only, my lord.
From our chart,
Yes,
what
yes,
what we are
definitely.
following.
Yes.
So anyhow, we are not following that. We have a chart. As per the chart, it is 15,500 in this case.
According to my lord, my lordship
So if it
may
is 15,500, how much is per day? For
15,000.
26 days, 15,500 divided by 26. It's coming to 596.
Correct.
596 for unskilled.
Skill.
Unskilled.
Unskilled. That chart is unskilled.
As per the chart,
Yes,
unskilled.
yes.
So we will take 700, not 596, that is 600 almost. If you take another 100 more, it's going to 18,200.
1,000 rupees, my lordship may increase. Because, my lord, they have not established anything. my lord.
We will take
Except producing
1,500.
that.
We'll take 1,500. 15,000 for 16,000.
500.
500
Yes, ma'am.
plus another 500, 7,000, 17,000. So where is, what is the age?
31 years, my lord, 16 multiplier.
So we are taking 16,500 will take. So 16,500, 40% future prospects.
Yes, my lord. 6,600, my lord.
6,600. It's coming to 23,100. Who are the dependents?
4 dependents, 1/4.
Four depends. Wife, daughter, parents, my lord.
5775, my lord.
5775
Yes, my lord.
minus 23100. It's coming to 17,325 into 12 into
16 multiplied.
16 multiplier.
it's coming to 33 lakhs. $17,325 into 12 into, you said?
16 multiplier.
16 multiplied.
Into 16. Yes, it's coming to 33 lakhs 26,400. Next, 4 into 44. 176. 36. 10. $35 lakhs 48,400. No, if it is acceptable to all of you, from Monday we will do, will whatever the list of earlier matters, date given, hundreds are coming. Unless there is if any stay petition is there, I'll ask them to list in a separate list. All that list, I'll give some dates because it's unnecessarily wasting time and no disposal at all.
Yes.
Only for this, it's going like a call work. So from Monday, I'll do that. Whatever the matters that are coming from the
Date
earlier
given
bench,
matters. Date
I'll
given.
give one on the, you all have to assume that that list is going to be adjourned. So nobody has to wait for that list. I'll take it as a last list. And at end of this, she'll give the dates. Nobody has to stay back. Before that, we'll have another MFA list where we will hear the matters instead of wasting time on. Please come. The agreed with the orders passed in. That you do. All the date given matters of the earlier bench in one list. But look at it, wherever any stay petition is there in that earlier matters, that to be listed in the third list. In the third list, all hearing matters to be posted. No. Fourth list is earlier courts, date given matters. That's a fourth list. From that list, if any stay petitions are pending, that you get it into the third list. Third list, post all final hearing matters. So that at least 20, 30 final hearing matters. Whatever the matters to be heard on 4, 5, those date given matters. And from the date given matters, any stay matters, stay petitions are pending, that should be come to the fourth list.
In a week, any 2 days, it may be given to the MFM matter.
That is not possible because of the DRT matters and all. If that, then you will never, the others will not get the chance. For you people, it's fine. If I take exclusively these matters, the writ petition under that FC matters and DRT people, they will make a big hue and cry.
At least 2 days. Second list or first.
No.
third
Now, I'll tell
We
you.
will
Now
take a chance, otherwise.
No. What will happen is, if we take up one list, by 3 o'clock, if I start, 20, 30 matters of final hearing, we can complete.
Yeah.
That would be sufficient for you people.
Correct.
So all those, she will only give the dates for all the fourth list, fifth list.
The medical bills has to be added.
How much?
3,54,600. 54,600.
It comes to? That's coming to 39 lakhs, 3,000, 39 lakhs, 3,000, I think. Correct?
Please.
Yes.
Yeah, it comes to 39 lakhs, 3,000. Agreed with about pass on MSC number 28870/2022 dated 1st April 2024. With the quoted granted compensation of an amount of rupees 36 lakhs 84,100. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. How much is sought?
20,000 per month.
Claimed amount.
Claimed amount 50 lakhs, my lord.
50 lakhs.
Yes.
For the death of the deceased in the accident. It's a case of the claimant that the deceased is earning 20,000. He studied SSLC and he has completed.
Completed fitter by profession ITI.
ITI course.
He has
ITI.
completed ITI course, but the court has considered the income as per the table and has taken 15,500.
Yes, ma'am.
15,500, which is for the unskilled laborers. It is submitted that he's a skilled laborer and the court ought to have taken 20,000 as income. It is submitted that the amount that is awarded by the tribunal is not just and reasonable. When counsel appearing for the respondent insurance company submits that the court had rightly considered and granted the compensation. It is submitted that just doing ITA course itself is not a ground for the court to treat him as a skilled laborer. It is submitted that no evidence is produced and the court had rightly considered and granted the compensation. There are no grounds to interfere. Next, having words answer. The only issue that is involved in this case is about the income. Undisputed facts are he has done his SSC and he also has done his ITI. No doubt there is no other document that he is working. As rightly submitted by the land council, the court cannot consider the same salary as that of an unskilled labor. For the unskilled labor for the year 2022, this is
22.
15,500. Considering the submission, this court is taking 16,500 as the income. 40% future prospects would come to 6,600. That is 23,100. If one fourth is deducted toward the personal expenses, that is 5,775. His contribution to the family would be 17,325 into 12 into 16. Under the head of loss of dependency, 32,26,400. Towards the conventional heads, 4 into 44, 1,76,000. Funeral expenses, 36,000. 10,000 towards the legal expenses. Altogether, the claimant and the court had already granted 3,54,600 as the 3,54,600 towards the medical expenses. Hence, altogether, the claimant is entitled for an amount of rupees 39,03,000. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 36,84,100 to 39,03,000. Accordingly, the appeal is partly allowed. Yes. Next.
For the appellate, my lords, it may be taken up next week, my lords. The only one ground, the petition is under 163A.
Huh?
The petition is under 163A.
Yes.
The only ground that the compensation at the head of medical bills was awarded excess of 15,000. It has to be limited. That is the only one ground. The trial court has laid upon the division bench of this court and awarded the amount to the extent of 2,22,000 towards the medical bills. Only one.
Let's hear her. This is matter on 28.
Oh, blessed.
Is 64? Yes.
I request in the next week because it may take some time because 50% contributor negligence has been fixed on the petitioner as he was crossing the main road, a nice road.
Very simple issue that is, it takes only 5 minutes.
Because
Please
even
give the file.
I have taken the papers of my learned counsel and appearing for the other side only. I didn't have any complete case papers. So by going through the evidence and all, your lordship, even the judgment also, we have examined the officer in charge of the highway who has deposed that there was a board.
Yes, this is matter on 12th of November. The 65.
For the respondent number 1.
My lord, the appellant is aged about 39 years. Sir. He sustained a fracture of 5th to
Come to
10th.
the table.
The date of action 7/9/2000.
Table.
Table. In synopsis, my lord, in first page.
It's there at page number, internal page 14. What are the injuries?
My lord, fracture of ribs, 5th to 10th ribs. With right
Is that para 15? 15 it is mentioned.
blunt injury or trauma abdomina with liver injury, grade 3, my lord.
So court has granted. What is the disability as per the
Disability is
doctor?
25% to the liver, my lord.
25% to the liver.
Liver, my lord. The trial court considered 20%. The honorable.
I think we will split this pain, suffering and amenities.
Pain, my lord, other grounds, my
Well,
lord.
no, what we'll do is,
Pain and suffering is awarded very high, my lord, 1 lakh.
amenities also included in that. So that's why we'll split it, so that the things will be clear. So under the head of pain and suffering, with these kind of injuries, we'll grant 1 lakh.
And food and nourishment also, my lord, is
So that we will
70,000.
see one by one step. Then loss of income during later period. How many days he was in hospital?
My lord, 25 days, my lord.
Which year is the accident?
2022, my lord.
So 15,500 into 4. It's coming to 62,000.
The trial court awarded 72,250.
On what basis? How many months it is granted? How much is taken as income?
Income is, my
Then
lord,
we will continue the
515
same.
per day, my lord. 15,500.
72,240.
70 days was maybe.
Yes, we will take it as it is 72,240. Because my calculation is coming less than that.
Yes, my lord.
Then
Lord, court has committed mistake, my lord, there. Court has taken 70 days, my lord, per day 516 court has taken. And also attendance charges, it is included,
One
not.
minute.
Also included in
conveyance is 25, correct.
25,000.
Incidental expenses, 25,000 is correct. Because he was there in the hospital for 25 days. 25,000. Then food and nourishment, 70,000. What is this?
Food and nourishment 70,000 is awarded.
How can it be?
But he is the liver. One person was attendant to that patient, my lord, for 25 days.
Let's see that discussion why it is granted 70,000.
Their attendance charges is also awarded, my lord, 72,240. My lord, per day it is taken as 516. And also for one attendant, my lord, court has awarded 36,120. Para 16, you lordship. As far as discharge summary produced.
According to you, where the enhancement is
My lord,
required?
enhancement, my lord, the loss of the future loss of income, my lord. 25% with doctor assessed the liver disability, my lord. The trial court considered only 20%, and future prospect may be added for that disability.
We'll consider only that. The remaining other heads, I will not go into. All are like exorbitant.
Only that.
So-
Even on my lord, future loss of income and so, my lord,
So
taking into
it is
consideration of the.
15,500 into 12, 15,500. What is the age?
39 years, my lord.
So 40 divided by 100 is 6,200. $500 plus 6,200. It comes to 21,700 into 12 into 15 into 20 divided by 100.
May I make one submission, my lord? Para 15, you lordship may kindly see.
Yes.
Lord, as far as the future loss, the disability is concerned, Lord, doctor has not said, my lord, the whole body disability.
Liver disability is
How many in a person's body, you cannot like it is liver affected, the entire body affects her. How can it be, it is not, if the
No,
claimant,
doctor
if you
has
lose
said,
his
my lord.
eye, brain, they are all one.
Right.
So it is not one hand, one leg. It is not about the limb. A liver is an organ in the body which will have an impact on the entire body.
Doctor evidence, my lord, has to be looked into. My
We
lord.
don't have to look at it as a, it doesn't have to say that.
But even 25%, my lord, is on the higher side. What the tribunal has taken.
You
by
have not
20
questioned. Once it is 20%, we are granting future prospects. That too, liver injury will have an impact on the life. It's coming to 7,81,200 minus 5,58,000.
Two lakh 30.
So that's what we need to add to this. 10,25,000 plus 2,23,200 plus 10,000. It comes to it comes to 12,55,757.
757. 757.
The
My lord. See, wherever, my lord, the award is on the higher side, your lordship has to reassess it. Even in many cases, your lordship has done. My lord, the pain and suffering is awarded, my lord, more. Even, my lord, food and nourishment, 70,000 is awarded. There, your lordship has to modify it. Since you are,
Amenities and pain and suffering include.
include ಅಂತ
1,20,000.
my lord, 60,000 to, my lord, pain and
happen
suffering.
is for the loss of amenity, that is, and the injury to the limb, to the liver, we will at least grant 50,000 towards
My
amenities.
lord, your lordship has awarded, my lord, future loss of income and also future prospect also. Therefore, my lord, pain and amenity, my lord, should be on the lesser side.
How is it?
My lord, 30,000, even, my lord, if it is 30,000 is awarded, my lord, pain and suffering should be, my
Why you
lord.
people, why the insurance company has not filed appeal?
No, we are satisfied with, my lord, we are not filed.
Then you are happy with whatever is done. Please come. Agreed with award
My
part.
lord, 70 food and nourishment, 70,000, my lord. Your lordship has done it in order to award just compensation, my lord. In many cases, your lordship has reassessed it and reduced the compensation. Even in my case also, your lordship has done it.
Pain and suffering and amenities.
Even though we have, my lord,
split,
for small amount.
60,000 rupees pain and suffering, 60,000 rupees amenities is awarded.
So
The
then,
trial court has considered
no,
both.
then 20,000 has to be removed from that.
And
So, please wait. So loss of future income, loss of income during laid up period. This also, 4 months is more than sufficient.
Right.
So 16,500 into 4 is 62,000.
10,000.
10,000.
10,000 rupees for attendant charges was included in that.
500. 1 minute. I'm on the loss of income during the laid up period. And one attendant charge. 72,240. Then conveyance, attendance already granted. So conveyance, what we do is, we'll not grant 25,000, we'll grant 10,000 for conveyance. Because already attendant charges are granted. Then food and nourishment. We will reduce 10,000 in that. It's 70, we'll make it 60. Medical bills as it is.
Food and nourishment, my lord, your lordship may make it 50,000, my lord. Even per day, 1,000 rupees if is taken, my lord, for food and nourishment. Lord, it would come to 30,000.
Because it's a liver injury, the court has considered that way. It's coming to 11,10,757.
My lord, only 20,000 rupees is reduced, my lord. 20,000 rupees is reduced in the.
Let's see from the beginning. Loss of future income,
Yes, ma'am.
7,81,200.
200, yes.
Then loss of income during the laid up period, as it is, I've taken 72,240. Conveyance charges have taken 10,000.
25,000 is trial court awarded.
So on the higher side, how does it make difference? Now, on all the three heads, for 25 days, we will grant 25. So there 10,000. Pain, suffering and loss of amenities, that component is not included. So what do you say about this? All will make it 1 lakh.
My lord, in other heads, my lord, is reduced, my lord. In pain and suffering and amenities.
20,000. So it comes to 12,10,752 against 10,22,557. What has been reduced is earlier it is coming to 12,55,000. Now it has come to 10. So put together around 35 is reduced. Please come. Agreed with award passed in MSME number 5682 of 2022 dated 7th February 2024. The claimant is before this court seeking enhancement of the compensation, and counsel appearing for the claimant submits that when the doctor has reported that he has suffered disability to the liver,
25%.
The court had taken 20%, but the future prospects were not considered. It is submitted that the amount of compensation needs to be enhanced. Claimant counsel appearing for the respondent insurance company submits that the amount of compensation that is awarded by the tribunal is on the higher side. He submits that under the head of pain and suffering, conveyance charges, loss of amenities, and food and nourishment, the court has already granted exorbitant amounts and they are not entitled for any enhancement. And no interference is called for. Next, having heard the counsels on either side, produce the material. First, coming to the contention of the land counsel, the petitioner, that when the doctor has given the disability at 25%, court had taken 20%, and no future prospects were granted. As far as taking the disability at 20% by the tribunal, this court do not find any reasons to interfere. However, considering the injury to the liver, which has an impact on the life of the petitioner, this court is inclined to grant 40% future prospects. That is 15,500 plus future prospects at 40, the person comes to 6,200. That is 21,700 into 12 into 15 into 20 by 100 is 7,81,200. Coming to the loss of income during the later period, along with the attendant charges, court has granted 72,240, and this court do not find any reasons to interfere. Towards conveyance, this court is granting 10,000. Pain, suffering, and loss of amenities. Already the amount of 1,20,000 that is awarded is on the higher side, and this court is granting 1 lakh. Towards food and nourishment, also 70,000 is awarded. This court is inclined to grant 60,000. Medical bills, as it is, that is 1,77,317. In the light of the law laid down in Mekala, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 12,10,752. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 10,22,557 to 12,10,752. Enhanced amount shall carry 6% interest.
Appellate counsel, praise for something.
What is this?
It's a case of injury, my lord.
Lissus matter on tomorrow?
Day of Monday and next week, madam.
Matter on 29,
Please, madam.
67.
Ready, my lord, can be disposed. Yes, my lord, ready.
Yes.
My lord, claimant's appeal seeking enhancement of the compensation, my lord. There was a fracture of femur, then my lord, fracture of second and third toes, and my lord, ligament tear. Internal page 9 of the MACT judgment, my lord.
Where is the table?
Table, my lord, gets it.
Page 12.
Internal page 12, my lord.
So, medical expenses as it is.
Please.
$32,481. Then loss of earning. How many days was in hospital?
6 days, my lord, he was inpatient in the hospital.
How many days?
6 days.
6 days.
Laid up period. How many fractures?
My lord, there are 3 fractures, my lord. One is fracture of femur, my lord. Then second and fourth toes fracture.
Which year is the accident?
My lord, here, my lord, there was income tax returns, my lord, filed by the claimant, my lord.
My lord,
The accident of the year 2022, my lord, notional income of 15,500 was assessed. But my lord, the claimant was, my lord, running a business, my lord, garment business, and he had produced income tax returns from the year 2019, my lord.
How much is the income per month?
My lord, average of the 4 years, my lord, 3 years average of income tax returns, my lord, exhibit P13 comes to 3,20,633, my lord. That would be, my lord, if it is calculated for per month, my lord, it will be 27,386.
but however, my lord, the honorable tribunal paragraph number 17 clearly states, examining the statement of accounts of his firm, they say it does not speak about the income properly. So they have gone as per the notional income of the.
We'll consider this. This is matter on 30th October.
My lord, 30 and 31st, my lord, I have some inconvenience.
Then November 11th.
Please.
This 68.
This case I appeal for
For the appellate in this case, madam. It's a case of injury. Award has been granted. This case, medical bill has not been paid and future medical expenses is not.
Medical bills not paid means?
Future medical.
Medical bills which are
Doctor says
submitted.
that, my lord, he require one more operation to remove the
implants.
That is not granted.
That is
no
not
amount
granted.
was stated by the doctor, no amount was granted by the claimant. That under head, my lord,
There is
My lord,
accident.
I have submitted the evidence.
Here is the accident.
2021.
But evidence is that operation is required.
Required, yes, madam.
And the 30,000.
And I have produced the estimate cost of the surgery as 1,65,000.
For removal of the implants.
Yes, ma'am. That is the estimate that was given.
But you have to examine the doctor.
Doctor was examined, my lord.
Doctor
has
said
suggested,
1,60,000.
Doctor, so far as the cost, doctor did not.
That is what is required. In every case, we are not granting 1 lakh or 2 lakhs as per that assessment.
Radius fracture, my lord. I don't know.
My lord,
on
but the
what
cost
basis.
given by the hospital is 1 lakh
But
approximately.
you have to
1 lakh.
examine somebody in support of it. Somebody should say, what is that? How is it called? Have you examined the doctor or have you
No.
put forth any questions to him?
So far as the cost, I have not put forth, but there was a.
That's why if it is like maximum 40,000 for the future operation, not.
In all other head, compensation is granted.
Huh?
In all other head.
Medical
sufficient
bill,
compensation.
was total 1,77,000 is what, 1,47,000 was paid by the insurer. Balance, it has not been awarded this.
What about that? Look into it, Mr. Srinagar, tomorrow.
Please.
Not tomorrow, my lord. I am out of station.
Globally, well, you also can grant globally of 50 or 60,000 and close the matter. So instead of.
On all the heads. What he is
No, no,
saying
not-
is,
Enhanced.
globally means
Distal
for the
end up-
medical and for the operation.
That's what. No, to
Together
it
he's
only
saying.
is, and, blood.
Is it acceptable to you?
No, my lord, I have, because surgery is
Yes,
required.
this is matter on 9th of October.
Yes.
Yes, like 69,
9th of November.
9th of November. Yes, 69.
I am for appellate in this case, the case of injury.
Who
my lord.
appears? Krishna Swami.
Krishna Swami, sir.
This is matter on 26th of November. Yes, passed over matters too.
Much of.
For appellant in this case, my lord.
55,275 would be the enhancement. I have written here, all those.
I agree, madam.
Take that.
Front side, madam, what is the list of papers? Claimed amount and all I have mentioned.
Agreed with award passed in MSC number 344/2022, dated 3/9/2024, paid by the tribunal has granted compensation of an amount of
Backside page, next page.
7,94,354. The claimant is before this court seeking enhancement of the compensation. When counsel appearing for the claimant submits that on the head of loss of amenities, considering the disability of
11.6%.
to the whole body, the court had granted only 10,000, which is on the lower side. Coming to the loss of income during the later period, court has taken the income.
14,000 per month instead of 15,000.
The court had taken 14,000 instead of 15,000. Coming to the loss of earning, future earning. What is the difference here?
I have written that, Lordship. Right side, I Court column.
No, no,
I
I've
mentioned.
seen.
Please, please.
15,000 into 11.6 into 12.
Into 12 into 16. 16
What the
multiplied.
tribunal has taken?
Tribunal has awarded also written. First portion, MSCT award. First column, MSCT award.
Yes.
Second column is High Court.
No, no, that you have calculated. Calculated 3,11,000.
3,11,808 MSCT awarded.
Flat that 34,080. So where the difference has come?
MSCT awarded 3,11,808.
That I understand. What was 15,000 into 11.6 into 12
Income.
into 16 is MSCT. Now what is done here?
Income has
MSCT
taken.
14,000 has come.
It's taken.
Yes, that you have not stated.
I have not written that.
14, So when counsel submits that, even with the head of loss of future earning also is entitled for enhancement. In fact, it is submitted that the tribunal has not granted a just and reasonable amount, and counsel appearing for the respondent insurance company submits that there are no grounds to interfere with the well-considered order passed by the tribunal having heard so and so so and so. When it comes under the head of pain and suffering, the court had granted, considering the injuries, an amount of 60,000, and this court and even under the medical expenses also, medical, food, under the incidental expenses, court had rightly granted the compensation, and this court finds no reasons to interfere. Coming to the head of loss of amenities, considering the disability of 11.6, this court is inclined to grant 30,000. Coming to the loss of income during the later period, considering the income at 15,000, this court is granting for 3 months 45,000. Coming to the loss of future income, 15,000 into 11.6 into 12 into 16 is 3,34,080. Future medical expenses, court had rightly granted 45,000, and no enhancement is called for. In the light of the law laid down in Mekala, 10,000. Altogether, the claimant is entitled for an amount of rupees 8,49,629. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 7,94,354 to 8,49,629. Enhanced amount shall carry 6%.
Much of it.
Next.
Case of injury.
Hmm.
There are three table para 19
Para 90.
There are 4 injuries, there are 3 fractures, fracture of right ankle, fracture of right.
But 80,000 is reasonable. Then how many days he was in hospital?
16 days was an inpatient,
How many days?
16.
That is also reasonable. Incidental expenses, 20,000. Then loss of income during which year is the accident?
2018, trial court has taken the income 9,000. As per chart, 12,500 to be taken.
So 12,500 for how many months it has taken?
6 months, trial court has taken. Difference amount is 21,000.
75,000 it becomes. Then loss of amenities. What is the disability?
That's correct, ma'am. They are not disputing only.
Doctor has stated
Under
24%. Doctor has stated 24%, madam.
To the whole body? Limb.
Functional disability, doctor has stated 40%.
No. If it is 24% to the limb, whole body it would be?
Trial court has taken 12%, madam.
8% to be taken, 12% taken.
Already taken. So loss of amenities, already amount is granted, and now no enhancement, we can, medical expenses as it is. 1,38,000. Future medical expenses.
That has to be considered as a, trial court has considered 9,000 income, right? 12,500 into 12 into
What I
50.
have considered, it is coming to 12,500 into 675,000. Future medical expenses, I'm looking at 50,000. It is reasonable. Then now, the loss of future income, that I will calculate now. 12,500 into 12 multiplier
Into 12 into 15, please, 15 multiply.
15.
Age of injury.
2,70,000 it comes paid.
1 minute. 15 into what is the disability? 12
12%.
by 100. It's coming to into 12 into 15 into 12 divided by 100 is 2,70,000. Legal expenses 10,000. It's coming to 6,93,000 against
87,000.
5,87,000. Please come. Agreed with the award passed in MSC number 1369 of 2019 dated 18/1/2024, whereby the co 22. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees.
Claim amount in 40 lakhs, restricted in the appeal, 20 lakhs.
40 lakhs, seeking an amount of 40 lakhs for the injuries sustained by the claimant in the accident. The tribunal has granted the compensation as per the table given below at paragraph number 19. Then counsel appearing for the claimant submits that the court had taken the income at 12,000, had taken the income at 9,000.
9,000, madam.
Excuse me. 9,000 instead of 12,500. Further, and on all other heads also, the amount of compensation that is awarded by the tribunal is not just and reasonable. The same needs to be enhanced. Then counsel appearing for the respondent insurance company submits that the court has granted a just and reasonable compensation. It's having got so. This court has perused the award under the head of pain and suffering, attendant charges, and amenities, medical expenses, future medical expenses. Court had granted a reasonable amount. Coming to the loss of income during the later period, considering the fact that this accident had taken place
27/11/2018, madam.
in the year 2018, this court is taking 12,500 and trial court has considered 6 months. So 12,500 into 675,000. Coming to the loss of amenities, court had lightly granted. Medical expenses, no interference is called. I already said that, no? I already said that, no interference. So coming to the loss of future income, 12,500 into 12 into 15 into 12 by 100 is 2,70,000. Legal expenses in the light of the law laid down in Mekala 10,000. Altogether, the claimant is entitled for an amount of rupees 6,93,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 5,87,000 to 6,93,000. Enhanced amount shall carry 6%. Yes.
It's a case of death, my lord. Date of accident 22/10/2023. Income claimed, my lord, 20,000. Compensation claim 33 lakhs. The MSCT has taken the income 16,000 as per the chart, my lord.
And what is that is?
And only conveyance led lordship has to be looked into, my lord. I have written.
Take that.
Only conveyance led. Loss of dependency, there is no interference requirement.
Oh, what is loss of
Three
consortium?
dependents,
How
my
much
lord,
is
major
granted?
son and married daughter. Three
Consortium,
dependents.
it was, how much was granted?
My lord, 45,000, 25,000, 15,000. That time, my lord, as for my lordship, 44 into 3, 1,32,000 and 36,000.
That's the only thing.
14 lakhs, 35,000, 164.
And where is 10,000?
10,000 at all.
The 10,000. It comes 4 lakh, 14 lakh, 45,000.
14 lakhs, 35,000, 164.
No, yours 35. Now it
4 lakh,
becomes
45.
Please.
14 lakhs, 45.
Agreed with award passed in MSA number 2081 of 2023, dated 17 March 2025, where the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 33 lakhs to the death of the deceased in the accident. The tribunal has granted the compensation as per the table given below. Then counsel appearing for the claimant submits that the tribunal has failed to grant a reasonable amount under the conventional heads, and the same needs to be enhanced. And the counsel appearing for the insurance company submits that the court has granted reasonable compensation and no enhancement is called for. Next, having heard the counsels on either side, there is the material on record. As far as the loss of dependency is concerned, court had rightly granted no interference is called for. Coming to the loss of consortium, how many are there?
Three,
Four.
three.
3 into 44, 1,32,000. Funeral expenses, 36,000. And in the light of the law laid down in Mekala, so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 14,45,164. Accordingly, the appeal is partly allowed. Yes. Done? Till tomorrow it is like this. From Monday we'll have that.
ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿ ರಿಲೀಸ್ ಆಗಿದೆಯಾ ಬಿಡ್ ಪಿಟಿಷನ್ ನಂಬರ್ 8433/25 ಅದಲ್ಲ ಸರ್ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೀಸ್ ಆಗಿದೆ ಅಂತ ಕೇಳಕ್ಕೆ ಸರ್ ಬಿಡ್ ಪಿಟಿಷನ್ ನಂಬರ್ 8433/25 ಆಯ್ತು ಸರ್ ಆಯ್ತು